Court of Appeal for the 6th District of the State of Florida is now in session. The Honorable Carrie Ann Wozniak, Judge presiding. All questions and things before the court draw near to the attention and you will be heard. May God save the United States of America, the state of Florida, and then honorable court. Please be seated.
Good morning, everyone. Thank you for being here today at this Law Day session of the 6th District Court of Appeal of Florida. I am Carrie Ann Wozniak from Orange County, and I am here today with Judge Jay Cohen, also from Orange County, and Judge Joshua Mize from Orange County. We have 3 cases on the docket today, and I know that there's going to be a switch of students after the first session, so we will take a break after the first session. But we're going to do a Q&A right after the arguments. So if you can stick around for that, and then we'll do the break after that. That's how we'll plan to do it. I want to thank a few people today who made this session possible here at UCF. Dr. Ronnie Zimmerman, the interim chair, Katie Connolly, the coordinator, RJ Aguilar, and Venetia Toussaint, the student workers. Thank you for having us here today and handling all the logistics. And I also want to introduce our court marshal, Charles Crawford, who is keeping us all safe today with his team. So thanks to everyone for being here today. With that, we'll go ahead and get started with our first case. It is case number 23-160, Tracy Finley versus Gymnastic World, Inc. Appellants and appellees, are you ready to proceed?
Yes, ma'am.
Okay. You may proceed. And please tell me how much rebuttal time you would like.
5 minutes.
Okay, great.
May it please the court, counsel, and today students who are with us. My name is Jason Gunter, and I represent Tracy Finley. And for the benefit of our students, I'll elaborate. She was the plaintiff below, and I'll also refer to her as the employee. I want to get right to the heart of this case, which is what we call the pretext stage of the burden of proof, because as your honors know, summary judgment was granted in favor of the defendant. But I want to do a lightning round.
Okay, so that would tell me then that you view this as a single motive case?
As you know, your honor, my evidence is the same either way. The court below considered single motive, mixed motive, and what I would just call circumstantial evidence.
All right, well, this was a summary judgment, and it appeared to me that the trial judge granted summary judgment on single motive theory.
The trial, we briefed all 3, and the trial judge granted it on all 3 theories: single motive, mixed motive, and what I would just call circumstantial evidence, convincing mosaic. Did you have enough to get past summary judgment? So,
All right, but pretext is, really, and that's a Lockheed Martin analysis, isn't it?
it's a McDonnell Douglas, all types of cases, a ping pong approach.
Well,
analysis, but
I said Lockheed, I meant McDonnell Douglas.
that is the heart of it, and that is what I'm going to be arguing, because that's enough to get, that's what I argue below, and that's enough to get you past all of the burdens of proof.
But the summary judgment, the analysis is completely different if we do a McDonnell Douglas versus a Lockheed Martin mosaic analysis.
Different in the sense, but if you establish pretext, you would probably get past all 3 because it really wouldn't matter. And in this case, I believe we created, genuine issues of material facts and pretext. And this was
All right,
discussed.
do we need to then to decide the issue of what test to apply?
No, sir. I'd say that's for the lower court, and they applied all 3. And if I established pretext, or there was genuine issues of pretext, that would prove all 3. So I would say,
How do you take that to a jury and you're going to give jury instructions on what? On all 3 theories?
well, the way that this came up in the lower court, when I received the summary judgment, I went to the jury instructions that I frequently do, and there's a causation instruction in there, as I recall, and the causation instruction is basically, do you find that the plaintiff was discriminated because of pregnancy? And then it says that it is a motivating factor, and it was almost like the Supreme Court's jury instruction incorporated the motivating factor standard in the jury instructions. So in the context of that, I briefed it in order to make sure that it was out there, and that's the way that it came up. And then it evolved, as you saw in the record, sort of a back and forth on this mixed motive, and that's the way that I briefed it. So I know there's subsequent case law talking about you'd have to concede one of the reasons in order to proceed in a mixed motive.
Do you think that the mixed motive test is a burden shifting back and forth test?
No, sir, but I think it can be. I think the crux of either test and is the crux in the question that's always answered in the new summary judgments standard, or where I normally would practice in federal court, and that is, do you find that there's enough evidence to get past summary judgment? There's no even on the jury verdict form, there's no standard interrogatories.
Do you think pretext is an issue in a mixed motive Lockheed Martin analysis?
I don't know whether it's an issue, but it's not necessarily required to survive summary judgment. You can still talk about it because pretext brings up motive and it challenges the reasons for termination. It's all goes onto the evidence pile in my view. But I don't think there's a lot of cases out there that really deal with mixed motive. I know there's some subsequent cases that talk about you have to concede one of the reasons to go in a mixed motive. The way that I viewed it is when I looked at the jury instruction and I briefed mixed motive as well in the lower court. The defendant, in any case that you file a case where mixed motive could apply, meaning that there's still liability if the employer was motivated partially by the prohibited factor, the defendant that when asserted as an affirmative defense, what's called the same decision defense, and then you would just proceed because they could still win if they would have made the same decision anyway. So when I got the motion, in order to, do everything that I could, I briefed all of, I'll call them the theories, and is what I did. That's it.
Well, the struggle is if you could theoretically lose under a McDonnell Douglas. I'm not talking about in terms of this case. I'm just talking hypothetically. You could lose under a McDonnell Douglas analysis, and potentially win on a mixed motive test under Lockheed Martin.
Yes, sir.
Well, how do we write an opinion on this if we don't know what test is going to be applied?
Well, again, from my viewpoint, I raised it in response to the summary judgment. I raised all three theories. The court applied it at the lower court. So if the court applied it, the lower court, I think ultimately would have to sort that out, whether or not it was timely, whether or not you had.
Well, aren't we kicking the can down the field then? Is it, and then we come back again on this case under the jury instructions? Because we don't know what test is going to be utilized below.
That is an issue that's maybe been partially, I know it's been talked about in federal courts, but I don't know that it's been resolved. From my viewpoint, the heart of this case still is the evidence on pretext, the reasons, the discriminatory intent. And
well, that's a McDonnell Douglas analysis.
That's McDonnell Douglas. Yes.
Has any Florida court used the other test, the convincing mosaic, and said that that's a valid test to use? Florida, not federal.
I use the word convincing mosaic. No Florida, all that I can think of, all the decisions are from federal court, whether it's mixed motive, the common one, which I'll call McDonnell Douglas pretext. The mixed motive, or excuse me, the convincing mosaic is simply some courts say, look, some of these are not hard and fast elements. You can prove them other ways as long as you have discriminatory intent, or you have evidence from which a fact finder could believe that the reasons are not credible.
Do you think Price Waterhouse compels the a mixed motive analysis?
I think, yes, if it's raised and the court considers it, I do, whatever the standards are. So if it's timely raised and the court considers it, I think it compels a mixed motive analysis, especially, when I look at whatever I looked at the time, the board of jury instructions.
But a mixed motive analysis is not a McDonnell Douglas analysis.
That is correct. That is correct. But I responded to a summary judgment just based on a McDonnell Douglas analysis. And in doing so, because of the jury instruction on causation, where it mentioned a motivating factor, I briefed all three. But again, I think this court today, from my viewpoint, the evidence on pretext was in the record, and that's what I'd like to also talk about, make sure I get.
Okay.
But real quick, for the benefit of everybody here, you know, it's an employment discrimination case based on pregnancy, wrongful discharge because of pregnancy. The prima facie case is not really an issue here, but the person is pregnant, there's knowledge of the pregnancy, an adverse action, and there has to be a nexus or a causal link between the adverse action and the knowledge of the pregnancy. That's not an issue here, and that wasn't an issue in the lower court. What's at issue here in the heart of it, I'll say, is still pretext. And there was evidence in the record for a fact finder to find pretext. Pretext is, it's scary when you look at the words on paper, especially when they're bold and underlined. It's basically showing that the reasons given by the employer are not credible or incoherent, but you can prove pretext either by attacking the reasons directly or indirectly.
I think this was an employee that had somewhat of a sketchy history in terms of time off, missing work.
Yes, sir. Although that wasn't raised until after the pregnancy announcement, which in the case law, that happened in the pregnancy announcement.
I'm not sure that the record supports that. Weren't there discussions with this employee prior to the announcement of her pregnancy about the amount of work that she was missing?
Well, to set the time frame of the announcement on January 2nd, 2019, the employer says we had discussions when she was hired, which was like April of 2018. Okay. A month after she was hired, not discussions, but she took time off to do something that was, her daughter was sick. A pre-planned or a planned vacation that the employer, she followed the employer's policies and the employer allowed it.
The employer accepting that the employee takes time off doesn't mean they were happy about it, right? In your brief, you kind of make a lot of that they didn't admonish her, they didn't make it, they didn't choose to discipline her until this final incident. But the fact that she came in and said, "Hey, I've got to take this time off and this time off," they said, "Okay." The fact that there was no admonishment doesn't mean they weren't unhappy about it, right? And they don't need a good reason, right? They just need a non-discriminatory reason.
That's true. And the jury can resolve that because we're looking at what happened on January 2nd, which the Osmos case, considers the pregnancy announcement and somebody responding indifferent as significant or probative evidence. Here on January 2nd, we had that announcement. Everybody says, yeah, she responded indifferently, the decision maker, to the point where later that day she apologized and then said at that time and in the litigation that, well, I did that because I thought she had marital problems. That's just further evidence that a jury would have to decide whether or not, that was pretextual. It was after that, to answer your question, that, the employer raised these issues. There was one absence. She went to a doctor. She got coverage. That was per policy. After that, she said, "Hey, I've got a friend coming in town." They said, no, she showed up for work. On January 23rd, there was this conversation between the decision maker and Ms. Finley, just those two. Ms. Finley's version of that conversation is, I was called in, she says, "You have a high-risk pregnancy and we're concerned about your future absences." That conversation, assuming it to be true under the case law, is evidence of discriminatory intent. If you assume all inferences in favor of our client, if you believe that, that's evidence of both pretext on the absenteeism and discriminatory intent. The decision maker says, well, in that conversation, I did discuss absences, but it's kind of vague whether or not she discussed the pregnancy. That was on the 23rd. She's terminated on the 29th. On the 29th, basically she's terminated for this cleaning issue. They say, well, we had somebody come to us and say either, well, they call it double dipping, or you weren't cleaning enough. The decision maker said, I viewed the video cameras, which, were later deleted or not preserved. And that was the reason. So the reason shifted a little bit. Then in the litigation, after the litigation, there was an unemployment appeal in which the employer at that time just said, she was terminated for the excessive absence.
We're well familiar with the facts of the case. Your argument, your basic argument then is that there's sufficient facts here for a jury to make this determination rather than the trial court, as the trial court did in granting summary judgment. Is that your, the bottom line to your argument?
That is the bottom line. If there is sufficient facts for a jury to conclude pretext and that the employer was motivated by pregnancy because of that timeline. And although, yes, an employer can say, hey, we're not happy, even though you complied with company policy, because of that timeline, that the jury should be able to say, look, because of what happened here, you know, we wanted.
Wouldn't that mean that any time an action was taken after an employer learned somebody was pregnant, no matter what the history of disciplinary action was, no matter how, you know, how bad the employee's history was, it was well, it happened after they learned she was pregnant. And what that would essentially mean is that there's always an issue of fact, right? That it essentially removes your burden to establish that the reasons given by the employer are in fact pretext. If all that is required to establish an issue of fact on pretext is they knew she was pregnant, then that essentially removes the requirement to establish pretext.
But respectfully, we have much more than that, because we have the announcement, which is considered under the law probative. We have the conversation where she's talking about, I'm concerned about your missing work because you're pregnant. If believe that's probative. So we have actual other evidence of pretext. We're not saying that, you know, oh, well, I'm pregnant and, you know, I lost my job. Most of those where summary judgment is granted, the ship was already sinking.
If it's a mixed motive analysis, pretext isn't the only critical aspect of it, correct?
That's correct. If it's
Now,
a mixed,
now the appellee has suggested that you've abandoned that argument. Have you abandoned that argument because your brief focuses almost entirely upon pretext?
no, sir, because the lower court below considered that argument, and I'm arguing the evidence, the same evidence, and we raised it, but the same evidence would be applicable to a mixed motive. You're just getting past whatever the burden is. That's the way we briefed it. So,
Counsel, in referring to those different tests, we have multiple federal tests or standards purporting to construe a similar federal statute. And I know there's some Florida District Court of Appeal cases saying, you know, we're going to use these tests to construe what we believe is a similar Florida statute. And both parties kind of assume we're going to do the same thing. Is there any Florida Supreme Court case saying we have to give any credence to any of these tests? If we just decide to determine we don't think the federal case law is helpful in determining the Florida statute, well, would we be within our rights to do so?
yes, sir.
And you're into your rebuttal time. But you may proceed if you want to.
Well, to answer your question, yes, sir, you would be, because I don't know that that's really been addressed by the Florida Supreme Court to answer your question directly. It still might come down to the new summary judgment standard.
So you agree neither party briefed whether these tests are helpful at all or whether we should adopt any of them?
I agree. We just assumed that way they were because that's what we do. I think this is Florida courts. These haven't trickled down. They have never trickled down in the context of summary judgment. These summary judgments often occur in federal court and are heavily briefed. I think, you know, this would be, you know, sort of saying, okay, where is the line, to answer your question? But to answer your question, no, Florida could, there's no Florida Supreme Court directly on case. And I want to raise one last issue. There was other evidence of intent, which I'm sure you saw on the record. There was this other employee who was pregnant, and in our conversation, we overheard admissible evidence, Ms. Rodriguez. When we find out she's pregnant, we're going to fire her again. I just put that on the scale. And maybe somebody would disagree, but there's enough there. These aren't just metaphysical doubts. There is enough there with that short timeline. And even the nexus is important. The nexus is so close and that chain is unbroken that can go on the pretext table and the bias table. But I thank you, and I'll sit down. Thank you.
You may proceed.
Good morning, Your Honors. May it please the court. Chance Lyman with Buchanan Ingersoll Rooney. I'm here on behalf of the Appellee Gymnastic World Incorporated. I'll just jump right in, Judge Mize. No parties briefed the application of which test to apply because the appellant abandoned a mixed motive theory. So in other words,
And not just which test to apply, whether we should apply any of them. I mean, these are federal tests for what some other courts have said is a similar federal statute. I didn't see any briefing from either party on whether the federal tests are a good way to look at this. It was all, you know, which test might apply. Did they abandon one test? I haven't seen any argument on whether these tests are helpful at all, as opposed to just looking at the text of the statute and whether You know, if the federal court's applying a test is not binding on us.
I would absolutely agree with that, Your Honor. There's no Florida Supreme Court precedent that requires this court to apply federal tests. There is Florida Supreme Court case law suggesting that federal case law is instructive in this area, but that's not a mandate on this court to adopt.
Yeah, why doesn't Price Waterhouse mandate the use of a mixed motive analysis?
Because it was not pled here, it was
Oh,
not.
no. That's a losing argument in my view, because you don't have to plead it.
Well, Your Honor, so two things in response
You
to that.
certainly aren't suggesting that it has to be pled when there's abundant case law that says that it does not have to be pled, that these are different ways of proving the cause of action, but that you don't have to plead whether it's a single motive or a mixed motive case.
So I have two responses to that. One, it's been abandoned on appeal and
Well, I don't agree with that either, but let's stick with the first part, which is, you said it had to be pled. And I'm
Yes.
suggesting to you that there is abundant case law contrary to that says it doesn't have to be pled. There's one case that says it has to be pled. There are a whole lot more cases that say it doesn't have to be pled. It's just a matter of how you prove the case, not how you have to do the allegations in the complaint.
So, yes, Your Honor, there's no Florida state court case that says it doesn't have to be pled. And what I cited was the Assad case from the third DCA that says the parties are bound by their pleadings when we go to summary judgment in Florida state court. And this is actually one of the tiny areas where the Florida summary judgment.
At summary judgment, they argued mixed motive, correct?
That's correct.
Okay.
I just want to say one thing about the Florida summary judgment rule. Even though it's adopted the federal standard, it has one critical distinction with the requirement that the opposing party file their response 20 days before. I know there's a case from the fourth DCA right now, the Mizell's case, that talks about the importance of that response. And I just offer that to Your Honors to show you that those federal cases talking about excusing parties from pleading mixed or single motives, those really would not apply in Florida state court under the.
Is there Supreme Court law that says you don't have to plead them?
Florida State Supreme
No,
Court.
United States Supreme Court, the people up in Washington DC.
Not under the Florida Civil Rights Act. There's not.
Under Title VII.
Under Title VII, yes, there is.
Okay. And Title VII is what the Florida statute's based upon, is it not?
So with one critical distinction, Your Honor, if we were, again, I didn't brief this because I believe it was abandoned. I understand Your Honor disagrees, but the Florida statute is actually substantively different from the federal statute because the federal statute has a mixed motive statutory provision. The Florida statute only has the because of statutory provision. So again, the federal statute has two of those.
It's silent, it's silent, but the Florida, there's no question that the Florida statute was based upon Title VII.
In its origin, Your Honor, but I believe actually time-wise, the federal.
Yeah, the federal statute was amended after the Florida statute was written, correct?
That's correct, Your Honor.
Yeah, and we did not, the state of Florida did not amend its statute to comport with the federal amendment.
That's correct, Your Honor, and I would absolutely make that argument for why there is no actual mixed motive option under the Florida state statute. Another example is.
Really, did you move to strike or did you make that argument below?
No, Your Honor. That was actually a supplemental briefing issue where we did, we argued that mixed motive was not pled and could not be considered for the first time. And then we cited some federal
But
cases.
you never argued below that the statute prohibits the utilization of a mixed motive theory of proof.
That's correct, Your Honor. Just truly, our position is that it was not raised. It was not raised below by the opposing party.
Well, you certainly knew it was raised below. Your argument's been that it wasn't preserved on appeal because the brief focused on the pretext.
I think to clarify, our position in the trial court was in our supplemental briefing, the plaintiff did not raise mixed motive. And then we cited federal case law that said, yes, there's price, but when there's no allegation in the complaint that even remotely suggests that mixed motive would apply, and critical there, Your Honor, is you need to allege that there were legitimate reasons. And I think that that's another reason why abandonment is here on appeal, because every single reason was attacked. You'd have to concede that something was legitimate in order for mixed motive to make any sense. That's what the quick
Yeah.
piece. That's-
What we're trying to do here is to get to the essence of a discrimination statute. And you certainly got to be well aware of the criticisms of the McDonnell Douglas that it does not, in fact, do what the intent of the legislature, whether it's state or federal, went after, which is to stop discrimination in the workplace. Isn't that really what we ought to be focusing on, is a test that accomplishes the goals of the statute?
I would absolutely agree with that, Your Honor. Yes, the Florida statute, which does not have a mixed motive provision in it.
I guess you have us at odds because I disagree with that completely. Whatever goals they had, they passed words. And our words are different than the federal statute.
I would agree with that. I didn't mean to disagree with that. It absolutely is a plain.
Well,
it-
there's a reason that we put Judge Wozniak in between the two of us.
Don't you envy me?
I'm sensing. it.
So how does this interact, the requirement to plead this, how does this, because we're talking about federal statutes require, the federal courts require pleading versus not require pleading. In addition to our statute being different, we have a different pleading standard, right? So we're a fact pleading standard, whereas the federal courts are a notice pleading standard. How does that interact with the obligation to plead mixed motive?
I think it requires it, Your Honor. I think it requires that they plead specific,
You
short and
didn't,
plain
you
statement.
didn't raise that below. Yeah, I mean, you never have really made an argument that he couldn't argue mixed motive. Not at the summary judgment as I read it.
Your Honor, in the supplemental briefing, which is in the record,
I'm talking about at the hearing on the motion for summary judgment.
there's no transcript of that hearing in the record, Your Honor. So there's not a record to show that we didn't oppose that, raise that issue at the hearing. And I believe that that requires affirmance under not this court's case law, but other district courts of appeal. And yes, Judge Mize, short and plain pleading standard, but it does require facts. And as we pointed out in our supplemental briefing in the trial court and in our appellate brief here, there was no fact that showed there was any legitimate reason for termination, which is really the critical fact for a mixed motive theory, assuming it even exists under the Florida statute, which I don't believe it does. And I'll say one more point on that. The standard jury instruction is sort of the only case law that I've ever seen on whether this is or is not the law.
Standard jury instruction isn't case law.
That's absolutely, well, I'm sorry, the adopting opinion from the Florida Supreme Court mentions, actually, and I believe it is in the standard instruction, which is.
Yeah, well, when the Supreme, first of all, they've gotten out of that business completely now. But,
Yeah, that's
but,
adopted.
yeah, but when they did do that, they always had a caveat saying, well, don't rely upon what we're telling you.
That's absolutely true, Your Honor. And I just offer it because there is, Judge Wozniak, you pointed out, there is no Florida court that's applying the mixed standard. And the jury instruction actually says no Florida court has ever decided this issue. So I just offer that as an indicator
Well,
that.
do you think we ought to decide that?
No, because it hasn't been briefed, Your Honor, and I understand that you do disagree with me on that, but I think that there's two critical reasons that it's been abandoned on appeal, actually three. The third one being, I think the oral argument presentation today pretty much confirms that the only debate is regarding pretext. Even the federal courts say pretext is irrelevant to a mixed motive case, and then of course I just can't let it go. The complaint does not say anything, and the briefing doesn't say anything about a legitimate motivation for the termination. And you need that for a mixed motive because, of course, it applies that you had mixed motives when you terminated, the decision maker. So because that's not present in the briefing and the record and the arguments below, I don't think it can be decided by this court. I'll, of course, answer any further questions, but just a few comments on the evidence that was highlighted. Again, we're in a single motive case where you don't have to just show pretext. You need to show that all of the proffered reasons were both.
Well, okay, are you going to rely upon the cleaning aspect of this case?
The non-clean, yes, Your Honor,
Okay.
yes.
And we have two instances. We've got she applies for unemployment compensation, right?
Yes,
And then there was an EEOC complaint.
yes.
Yet neither of those proceedings did you all raise this cleaning, non-cleaning, or the lack of proper cleaning as a basis for firing her. The only basis that was raised was the fact of missing too much work. Now, you don't think a jury could take the fact that you didn't raise it at the EEOC complaint level, you didn't raise it at the unemployment compensation level, and say that that's not pretextual to now raise it?
Your Honor, no, I don't think that is a question for the jury, but I can sort of set that
Why
aside
not?
for a moment.
Why couldn't a jury say, well, wait a minute, if that's really why you were firing her, you should have said that?
Well, because Your Honor, to actually meet the pretext standard, you'd have to show two things. You'd have to show that it was actually false is the first thing. And that's the hurdle they can't get over.
Well,
So
we can talk about that too. Even on the firing, these were instances where she asked for time off. When they hired her, she knew they knew she had a vacation scheduled, and they hired her understanding that. And they approved every request that she made for time off until she announces that she's pregnant. And then they deny the time off, and then they fire her. Now, how can you approve the time off and then fire her for excessive absences?
so one thing, they did not approve every single,
They did up until the time that she announced that she was pregnant.
actually, Your Honor, there was a New Year's Eve time that she requested off. They said
And did she take it off?
she did not take it.
Okay, so,
Or-
okay, so she didn't take it off.
I believe the record code was there was one instance in which she requested time off, they denied it, and she worked the shift. I believe it was a single shift.
I believe that's correct, and I apologize because I thought there was one before the disclosure where she did get coverage for the shift, and that's, I thought what I was thinking.
And the
of,
employer told her not to come in, right?
that's it, Your Honor, and I think that that's substantiated in text messages, which I did want to say, you know, there's a lot of complaints about a lack of documentation. I think the only documentation in this case actually refutes the plaintiff's case.
Well, you know, I'll tell you, part of this is your own, not your own, but the employer's own doing. They had no one else present at the meeting where they fire her. That, you think that's a good procedure, a good process?
Your Honor, all I can say is that the record reflects that's consistent with gymnastics world.
Okay, so they approve the time off and then they fire her for excessive absences. Can't a jury make that determination that it was pretextual?
Your Honor, again, I guess I'm assuming that this court will accept the pretext standard that's been articulated by the federal courts, which requires falsity and that discrimination was the actual reason. Because it's not false, the jury can't reach the issue. And there's no evidence that it is false. And I think it's important to re-articulate that it's not just absences, it's reliability. And again, this is something that was mentioned in the interview, which Finley concedes. This is something that was mentioned in April, where there's no dispute that the decision maker considered and told Finley she was considering terminating her in April of 2018 for the disclosure. And that was after 1 month of work with 6 absences. Then there's a period in, I believe it's November, when the plaintiff asks for more time off for a second vacation. That's going to take 7 work days, it's 14-day vacation. At that point, there's no dispute that, again, the employer is expressing concerns to this employee about the reliability pattern that's evolving here. And then we go forward to, so just to be clear, those are all pre-disclosure.
Okay, but they don't put any warnings in a file. They don't do much of anything until she tells them that she's pregnant and that it's a high-risk pregnancy. And then oddly enough, soon thereafter, she gets fired.
Your Honor, I don't think it's odd. Two things. One, Finley concedes each and every one of these events that I just described. So the documentation aspect is irrelevant, I think. Two, there is no law or case law that requires documentation.
Counsel, does the lack of creating a paper trail and having somebody else present at the meeting when they were terminated in any way pertain to the substance, or does that pertain to whether an employer follows, legal risk protection to avoid lawsuits regardless of the substance of those lawsuits?
It does not involve the substance at all, Your Honor. It would be immaterial under the summary judgment standard, which we've adopted today. The other factual issue I just want to highlight is the pregnancy announcement issue. That is 100% demonstrably in conflict with the documentary evidence. Okay, there is a text message, it is in the record where the plaintiff says that she did not announce the pregnancy with positive feeling. I'm sorry, I forgot the exact language she says. I didn't say with excitement, I think is the exact phrase. That's consistent with literally every single person's testimony regarding the pregnancy announcement. So that can't be evidence of pretext at all. That one has to be simply off the table. And again, if we're only talking about reliability, which was, Judge, going back to your issue about whether there were shifting reasons, there's no dispute that reliability was always given as the reason. And so that's why this case can't go to the jury, because that's not false and it wasn't one that shifted. So just because I also, regarding the non-cleaning issue too, Your Honor, I'm recalling now that in the briefing from the appellant, they're actually relying on statements that basically conceding that the employer did make statements during the termination interview where she brought up the non-cleaning. And then I think that's the comment where she says, maybe I'll.
Well, they asked at the EEOC, the basis for termination and cleaning wasn't raised at all in the EEOC response.
And Your Honor, I don't want to get those confused, but I know that I don't think there was ever a request to list every single reason. And I'm not familiar with case law that would require you to list every single reason.
But a jury could look at what you put on the EEOC response and draw inferences from that.
I don't think the jury can reach the issue again because it's not false.
Is the employer bound? Is there a law that says the employer is bound by the submissions to the EEOC? Is there like an estoppel doctrine or the responses to the unemployment compensation claim? Or does that just come up like as impeachment, as like a prior inconsistent statement or something like that?
The only law that I'm aware of that's been cited in the briefing certainly is federal case law suggesting that it would be indicative of pretext, of course, assuming you could meet the other standards of a pretext.
Why isn't this like any other summary judgment case where you've got conflicting evidence and let a jury make this determination rather than a judge do it, give her day in court? Let her peers decide this issue, not a judge.
Well, Your Honor, I would respectfully argue that this is one of those cases under the new standard that this is a scintilla case that might have been appropriate to take to the jury under the old rule, and that's not appropriate anymore. And bringing the soil of the federal judgment rule, with the exception of the response timing, I think that that we now can adopt those federal decisions that don't let these issues go to the jury when it's a single motive pretext case.
Well, I don't think Judge Mize is going to go along with it.
And I'm of course trying to make sure I've answered everyone's questions and concerns. But if that were a way to approach this case, that's certainly why just one of these reasons proffered, if it's not false, is dispositive of the issue for the purposes of summary judgment. That's, of course, if this court were willing to adopt federal case law that's already there.
Counsel, could I ask you one more question about the unemployment? As to the cleaning, are we sure that's something that the employer could have raised? And here's what I mean by that. I'm not an unemployment compensation expert, but the cleaning was outside the scope of her job. That was a separate employment, that was a separate contract they had with her. Right. So the alleged misconduct with respect to that was not actually in the scope of her employment. Now that might not affect, their ability to fire her for it, because if you just find out your employee is dishonest, right, you find out they're stealing from somebody completely different than you, you can still fire them if you just think you're a dishonest person. But it may go whether or not even though you can fire them for that, it may not be something you can raise in the context of an unemployment hearing, an unemployment compensation claim, because it wasn't in the context of their employment. Is there anything to that?
I would agree with that wholeheartedly, Your Honor, but of course
You
I don't.
understood it?
I'm sorry.
You understood it? I'm not sure.
In other words, if they were
Yes,
fired, if they were
absolutely.
fired for something that is a legitimate basis to fire them, but did not occur within the scope of their employment, is that something you can raise as a defense to an unemployment compensation?
I would imagine it would be irrelevant, Your Honor, because as you pointed out, it would be a compensation issue and probably one that involves what the actual.
In other words, it's not a for-cause termination, even though it's a valid basis to fire someone under the unemployment compensation statute. It's not a for-cause termination if the cause occurs outside of your employment.
I would agree with that. The last thing I'll say.
And your
is-
time is up, but go ahead and finish your thought. You can finish your thought.
Just the next, I think Judge Mize, you articulated this earlier. You can fire an employee for a good reason, a bad reason, as long as it's not discriminatory one. And so I would just leave the panel with that.
Thank you. Appellant's counsel. 2
Right.
minutes and 58 seconds left.
Okay, so I do want to address something on the unemployment. Don't forget, there was another reason that was articulated through the record, which was disrespectful conversation or attitude. That was raised in the EEOC proceedings and in the EEOC, it's called the position statement. And it was characterized at that time as disrespectful attitudes towards a staff or a coach, none of which, was in the record. That could have been brought up at the unemployment appeal to show misconduct connected with work. And just as a practical matter for impeachment, people put whatever they want in the unemployment appeal just because they want to show everything to avoid, unemployment. One of
It's
the,
also stealing hours. What did that go to?
what's that?
Stealing hours? I
Well,
haven't
stealing
heard that.
hours is duplicative with the cleaning. They've articulated the cleaning as you weren't cleaning enough or you weren't doing it, you weren't there, and we made measurements or whatever we did, or we looked at some video and they said, because you were on the clock and because you were allegedly cleaning on the clock, it was characterized as cleaning hours, which we think is piling on, which is another evidence of discrimination. Briefly, the characterization of the pretext test is not that you have to prove that it's false and you have to prove that it's intentional discrimination. It's that you have to raise a material fact from which a jury could say, hey, we didn't think these are not plausible, credible, and they can infer that it was false. And then the jury, if there's enough bias combined with that, can infer from the record. I want to address the what you've been talking about, Judge, on the mixed motive. When I briefed this below, and when I did, I get the summary judgment. I get a summary judgment. The United States Supreme Court, as I recall, it's in the record, the justice does talk about it. It's one of the justices that said there is no neat labels on a pleading saying, I'm pleading this now as a mixed motive or single motive. I could never do that at the beginning.
Counsel, I want to ask you the same question I asked your opposing counsel. How does the requirement to plead, there's federal case on the pleading standards, but we have a different pleading standard in the state of Florida. So why are we looking to federal case law on how to plead something when we have a completely different pleading standard?
I would normally plead it the same way, material facts, to support my case. But I don't think you have to say this is a mixed motive case. And at that point in time.
But you're pointing to federal case law on the pleading standard. The federal courts use a notice pleading standard. We use an ultimate fact pleading standard. So the fact that federal court says you didn't need to plead a particular thing, how is that instructive to us when we have a different pleading standard?
Well, ultimate facts, I think you could still prove, it would still be the ultimate facts of the case, meaning a prima facie case, she was pregnant, there's causal relationships, all the things that you would normally prove to get past, a bare bone pleading.
Well, the mixed motive isn't a fact. That's just a legal theory under which you proceed.
Correct. That is correct. In the way that it just normally should proceed, it's subject to what they call the same decision defense. And so if you had a pregnancy discrimination case, because that, I don't know whether it's right or wrong, the jury instructions for the Supreme Court, I agree with you. But it said to me that.
Well, counsel, I think there are two different theories, but the name gives away the facts you have to prove to establish them, right? Single motive means that was your single motive. That is one fact. Mixed motive means you had more than one motive, one of which was the pregnancy. You would admit those are two different fact patterns, right?
And your
Sole
time is up,
motive.
but go ahead. and-
Two sole motive, multiple motives. Those are two different facts that could occur.
Two different theories in which, you would.
Do they involve different facts, counsel? If an employer has one motive versus multiple motives,
If the
are
law
those
says,
two different factual situations?
if the law says that you have to stipulate to a factual motive versus, a jury can decide, based on the.
I'm just telling you, does that pertain to facts? Now, aside from litigation, in a world, if an employer has one motive or they have multiple motives, are those two different statements, factual statements I'm making?
Not at the pleading stage necessarily. It's for the jury to decide. It could be a set of facts in which the jury says, we find that they were motivated by the plaintiff parking their car in parking lot C, but they were also motivated by pregnancy. And if Florida law says we allow mixed motive, the jury can find in your favor subject to the same decision defense. But it would obviously, if somebody said, if the courts want to say you need to make an election at some point, whatever it was, but it was raised And the Supreme Court says, at least they said, there is no neat labels. One of the justices said, it would be impossible for me to sort of say that at the beginning of my case. I'm stipulating that before any of it, I'm stipulating that, I was absent, or I'm stipulating that this occurred. But my time is up, and just thank you for the time, and thank you to the students too.
Yes, very difficult case, well argued by both.
Yes, thank you both. And welcome to the students who came in during the argument. I mentioned in my opening remarks that we're going to have a Q&A session now, if council are able to stay for a few minutes to talk to the students. I think we can start by maybe introducing ourselves a little bit more and our background first, and then we'll turn it over to council to introduce yourselves. Judge Cohen, do you want to start?
No.
Okay. I'll go first. I'm Judge Wozniak, and my background is actually doing what these counsel did, doing appeals, civil business litigation appeals. I was appointed to the 5th District Court of Appeal, headquartered in Daytona, back in, it's been about 2 years, and then the courts were redistricted, and the 6th District Court of Appeal was added as of January 1st of this year. So I moved over along with Judge Cohen to the 6th District. And fun fact, Judge Mize and I used to work together in private practice back in the day. So it kind of comes full circle that we're all here today.
She was senior to me then too.
I was, yes.
My name's Joshua Mize. I practiced commercial litigation for 11 years. I was appointed to the trial court on the Ninth Circuit in Orange and Osceola County in February of 2021. I served there through the end of 2022. And as of January 1st, was appointed to the 6th District Court of Appeal.
And I'm Jay Cohen. I've been a judge for 33 years now. I did 18 years or 19 years on the trial court, and I've been on the appellate court now for 14 years. Much of it on the 5th District Court, and then they formed a new and critically needed 6th District Court of Appeal in Lakeland, and so that's where I am at now.
Counsel, go ahead.
Good afternoon, everybody. My name is Jason Benner. I'm not an appellate lawyer per se. I don't know if you can tell that. I'm the person who lost the level. And so some lawyers like myself, we lose and we appeal our own cases. Other cases, there are appellate lawyers who respect us. But I wanted to make one comment. You can see us. I'm a lawyer. This was an employment law case or an employment discrimination case. Really interesting question. But important to ask you. If you look, and you probably saw the briefing, there is this complicated, we call it a ping pong analysis, and you do this, and it's scattered throughout the courts. That's how that's how everybody it was a case law developed. Somebody said this is where we're going to do it, and they ping pong back and forth rather than just, hey, did you? So that's interesting. I think that's interesting something you can follow because that is something that other courts that I appreciate it.
I'm Chance Lyman. I am an appellate attorney primarily. I do about 90% appeals. I actually recently got board certified in appellate practice. That's something you can do, in law. We can get a lawyer to do that in Florida. I work for a national firm in Rooney. We're based in Pittsburgh. We have offices all over the country. And unlike Mr. Gunter, I'm not really an employment specialist. I specialize in the appeals. So he was working with a different lawyer at the trial level, and then a lot of times that's how it will sort of happen. You pass the case off to the appellate attorney to the appeal, so that's when I get to come in, and it's really great because I always say it's a lot like doing like term papers in college. I think it's the same thing. You got a closed universe, or you got a cold record. All you're going to do is write an essay on that record, and then you get this very cool opportunity to come here and talk directly to judges about what you wrote. So it's kind of like, I guess, defending your thesis and at that point. But that's sort of the introduction for me.
Thank you both. And if anyone has any questions for us, the judges or counsel, please feel free to ask them. Don't ask us specific questions about the case, but you can ask counsel those questions if you'd like, but go ahead. Anyone?
You can ask us questions, just not about the case.
Yeah.
Do it without student loans.
Good one.
Figure out where you'll get the best deal and go there.
I think we're, you know, some people say like, what you voted to hear about the Lord, right? But you know, we think the Lord is right. And it's like the fact that I'm a trial lawyer. And sometimes we get sloppy at the trial level, but learn early how to write. If you don't have the intellectual ability to do it, study it, read the books, practice it, know English grammar, it's fascinating. And if you learn to write quick, good letters, brief, complaints, you will have leverage over everything. That's my experience.
That's exactly right. I would completely agree with that. And when you're gonna start law school, the first few years taking writing, study that class, get to know the professor, work on it hard, because I think that's absolutely true. It helps you with every other class anyway, because what you're gonna do is learn how to dissect cases, and then if you go on with the word, that's all you're gonna do the rest of it. Primarily. Especially in the college context. That's literally all we do is what we do in legal ed. And I think that's that's kind of the only class in law school, at least of the ones that you have to take one step back in class and do the beginning. That's the only one that has practical application, in my opinion.
Wait, are you saying law school's really theoretical and doesn't bestow a lot of practical knowledge?
That is an eloquent way to put it. And I would absolutely see about find the right deal, because we, especially attorneys my age, we're still walking around with that, talking to each other. And so we can be here doing this job and stuff like that. So that's great.
I have a couple of thoughts that are interrelated. Say yes to every opportunity that you get, whether it's shadowing a judge, interning for a judge, being, a state, like working with the state attorney through their certified intern program, things like that, mentoring. If you have the chance for someone more senior than you or a judge to mentor you, definitely say yes to that. I clerked when I came out of law school, and I highly recommend that if you're able to do that. I really like learning from other people's mistakes. I make plenty of my own too, but whenever I can learn from other people's, I try to do that. And when you're clerking or interning for a judge, you get that unique perspective of the judge telling you, oh, I liked what that attorney did, or I don't like that. And it's really invaluable, I think. And I still think back to things that I learned way back in my early career from that. So that's what I have. Way back there. Go ahead. Sorry, I'm pointing. Yes, you.
Say that last part again.
Do you believe that there is justice in the system?
I think it would be hard to do our jobs unless we believed that. I have, as a judge, I have tried hundreds and hundreds of cases. And I think that the jury gets it right almost every time. I have great faith in the jury system. I think it's just a marvelous system, and I'll take the right to a trial by jury over the right to have a judge decide a case every time. So my answer to that would be yes. I do think that we, is it perfect? No, I don't know any system, whether it's legal, whether it's government, whether it's business. I don't know any system, that's perfect, because we're human, and as humans, we are imperfect. But it's the best system that I've been involved in and have studied. So my answer would be yes.
This might surprise you, but I agree with Judge Cohen.
That surprises me.
I think that the jury trial is one of the greatest inventions in the history of mankind for ensuring justice. I also think there's a common misconception that the word best means good or implies good, right? The word best means, it can either mean the most good, or it can also mean the least bad, right? And so every system will have, instances where every system will make mistakes, right? But the issue is, what rules can we put in place? What system we can put in place that will maximize the amount of justice, right, and minimize the amount of mistakes? And I think our system is the best in the world at doing that. I think compared to every other system, it's not perfect. You can always improve, but it is the system that provides the most justice and the least amount of mistakes compared to any other country in the world.
And I'm not surprised that they agree on that, because I think we all have the good intention to do justice every day when we put on our robe and think about our cases. That's what we want to do. So I think we have time for one more question before we need to take a break. Okay, you go ahead.
So the employer have a legal required the plaintiff within the pregnancy, or were there other
$1 question.
Yeah. And that, sir, is why we're here today.
One interesting thing you can do if you're interested in appeals, any person can sign up for an EDCA account with any district court of appeal, and you can download documents off the docket. So the briefs that the lawyers wrote for this case contain a lot more information, as will the briefs for the other two cases we're going to argue. If you go to the 6th District website, you can sign up and you can download all the documents for free. You can read their briefs, send them critiques, don't send them to us. And you can do that with any appellate court in the state.
Because you have so much free time.
And you can watch our oral arguments too on our court YouTube channel if you're not here in person. So I think do you have a really quick question? Okay.
On average, how long does it take for a person to transition from being an attorney to a judge? Or is there an average?
Happens like that. All of a sudden you get the call from the governor and you're up here.
I'll give you my answer to that would be this. I think it was easier to transition from being a lawyer to being a trial court judge. This is personal, it could be because I'm not as smart as these two next to me, but my transition onto the appellate court was longer for me to get comfortable doing what I was doing, a lot of writing, and I would say that that was a longer transition. It took me, I think, 3 to 4 years of being an appellate court judge before I got comfortable in that role. Whereas I think within a year or so going onto the trial bench, I felt very comfortable, within that role. But that's an individual thing. I think, that every answer to that could be very different.
And I'm still in that time frame, and I take the mindset that I'm a lifelong learner. Every case is different. I'm learning something new in every case, and I don't know if that'll ever change. Okay.
Yeah, I think the transition never ends.
Yeah. All right. Well, thank you all very much for being here. We're going to take a break and come back for the next case.
We're actually leaving. Is that what we're doing?
Yeah, I guess so.
Bring in extra resources. Years ago, figured out the idea of designating here. Didn't go very far, but I'm also exploring it. I said, financial disclosures last Thursday, I'm thinking I'll hold off on the 27th until the second year. I'll add it to the list. Every time I came with the name of the city, notice the oh, good. I almost sit back. Hey, see, here's my needs. Who named the city? So I think I'm hoping to maybe some stuff in the water, fresh water. It's not to be so. A lot over DC. I'll sit there and yes. That is so fun. Yes. Exam time, which is about I see the license. He said it's about All rise. Please be seated.
Welcome back, everyone. We will go ahead and get started with our second case, which is 23-482 Advanced Florida Medical Group Corp. Et al. Versus Progressive American Insurance Company. And I do want to comment quickly that there are going to be students coming in probably during the argument. So if it gets too loud or anything, we may take a pause, but I just want to warn you in case you start hearing shuffling behind you. And how much rebuttal time would you like?
5 minutes, Your Honor.
Okay,
Thank
thank
you very
you.
much.
You may proceed.
May it please the court, Jeffrey Molinaro on behalf of Advanced Florida Medical. Members of this panel, this case isn't about whether an EUL can be video recorded. That's the 30,000-foot view. But as the plane comes in, the question before this court is who can press the record button? Progressive says the only person that can hit record is a videographer, paid by my client at my client's expense. But Progressive also then says, if you pay for that videographer, you don't get a copy of that videotape. It's somehow work product. It's work product despite the fact that it's your own statements. It's work product despite the fact that your counsel's present. It's work product despite the fact that the plaintiff's counsel in this case was in the room.
Why would you record a lawyer? Yes, you're going to go in and you're not going to record the person being deposed. You're going to record the lawyer.
Well, Your Honor, my understanding is that there's no actual record evidence of what the videotape showed. That's the argument of Progressive. Progressive's argument has been, well, this camera's angle, much like the angle today, is it's focusing on the lawyer from the point of view of the examinee. But that's not a basis for prohibiting the videotaping. That's simply saying either one, move the camera, right?
Well,
Or
what indication is that, you know, you weren't the lawyer below, were you?
no, you're, oh, I entered an appearance after summary
Okay.
judgment.
Yeah, my sense of you reviewing this is that that lawyer wasn't going to cooperate with a request like that.
That I don't know, but that's not in the record, Your Honor. And that would then go to, which is a legitimate point. But that point would go to the policy itself. The policy itself has a provision that says that a insured has to reasonably cooperate with an EUO. But that wasn't what was pled.
Where does it say reasonable though? Because isn't there reasonable in the independent medical examination?
That's a statute, Your Honor.
Okay.
In
You're
the
talking
actual
about the-
policy
okay.
itself, under the policy itself, before the language that says we have the progressive has the right to take the examination under oath, there is a paragraph that says, which is form language, you have to reasonably cooperate in our investigation. Now, if they would have pled that, that would have been very different. But what they pled was that my client failed to appear, or excuse me, strike that the insured failed to appear because we're the assignee.
Counsel, I want to ask you about that. Can you get into the waiver issue on that? Because I looked at the sixth affirmative defense and they said failure to appear. And then you move for summary, your client moves for summary judgment on that affirmative defense. And there was an argument made by the other side that you needed to move to strike that, right, as if it was legally deficient, that if you were arguing that they didn't properly plead it. And it seemed to me that what you were arguing was something different, right? So you move to strike an affirmative defense when it's legally deficient, when it fails to allege as a matter of law an affirmative defense, if it doesn't meet the fact pleading standard. Here, the affirmative offense to me looked properly pled, right? Failure to appear is a defense, and they pled you failed to appear. That's the fact. The issue was, as I saw it at summary judgment, was at summary judgment, they argued something different. So you move for summary judgment on the failure to appear issue, and then they argue something completely different, failure to comply or failure to, properly submit, which not that could necessarily be an affirmative defense, it's just a completely different affirmative defense than the one that was pled. They argue you waived that argument by, allowing the argument to proceed at summary and other places. Tell me why you didn't waive the failure, because I think you've convinced me through your briefing the failure to appear issue is completely different than what summary judgment was granted on. So I'm not asking you to argue that they're different, because I agree they're different. Tell me why your client didn't waive the failure to plead the, properly complying with the EUO.
Yes, Your Honor. So first, I want to make the court's bring the court's attention to a notice of supplemental authority last week. Came out on April 5th. The case is Design Neuroscience Center versus Preston J. Fields, PA. Case number 3D20-1048, 2023 WL 2777480. That's out of the Florida 3rd DCA, April 5th. And that case held that where a party moves for summary judgment, raises new grounds for granting summary judgment for the first time in its reply to a response in opposition, but files that reply less than 20 days before the hearing, as a matter of law, the lower court errs in relying on those new arguments because 1.510C5 requires them to provide the factual support with their motion. How the third interpreted the rule is to say that what you've done is you de facto filed a new summary judgment. And if they can't do it in a reply, they certainly can't do it for the first time at summary judgment. In terms of
that doesn't
whether
address the waiver issue,
correct,
right?
and in terms of whether the issue was tried by consent, because let's say they came out of the box and we argued, I would cite to the court record page 1008 and 1009, motion for summary judgment transcript page 15 line, starting at line 18. I'd like to actually read it to the court, if the court would grant me brief leave. Starting at page 1008. I think we need we should start with the pleading here. If the court looks at the defendant's answer in affirmative defenses, which I have a copy here. If you look at affirmative defense number 6, they're specifically alleging plaintiff's assigner failed to appear for an examination under oath. They failed to comply with the condition precedent under the policy, voiding any rights, benefits for the alleged date of loss. Their position from the beginning of this case is the failure to appear. That's what they framed in the facts. They didn't talk about anything about the contract or a work product or what have you as a video. The word video record or video record, is nowhere in their affirmative defense at all. So I believe trial counsel properly raised the issue in terms of preserving it, that it wasn't tried by consent. I think that's the difference between our argument that they waived any objection. They may have had the videotaping, assuming they even have a right to object. We argued below that they would have waived that right because they removed the constriction, the extra contractual prohibition from their pre-EUO correspondence. And they went to an EUO. They swore Ms. Weir in. They started asking her questions, all while thinking a camera was there and the camera was recording. We argued below that is either waiver as a matter of law or that gets kicked to summary judgment. Now, what we heard in response was, well, you didn't file an avoidance that said waiver. And the response that we had in our reply brief on appeal was, I don't have to anticipate an improperly pled affirmative defense. You said we failed to appear.
Well, now you're saying something different.
Oh, that's a different
Okay,
argument.
it's not. To me, the affirmative defense looked completely properly pled as a failure to appear affirmative defense. They named it. It is an affirmative defense. And they said your client failed to appear. That's the fact. So they met fact
Correct.
pleading standard. The problem is not that affirmative defense was improperly pled. It is that it is a completely different affirmative defense that was argued at summary judgment.
That was in essence our position. And our position in our reply brief has been, when I say we don't have to anticipate your unpled affirmative defenses, it's just that. Failure to appear, we filed a cross motion for summary judgment saying we appeared. Here's the transcript. Their own evidence shows we appeared, and that was it. And then they came back at oral argument and said, well, these are the reasons why this doesn't work and you should grant our summary judgment. They were all new, both factual and legal basis. So it was a different affirmative defense and a different argument that wasn't in the motion. We think that would violate both the pleading rule and the rule of summary judgment at 1.150. And if we turn to the merits, because we believe that not only is there a procedural ground for denying or reversing summary judgment, but there's also merits-based ground to grant our cross motion just on the limited affirmative defense. We're not talking about the entire case here. This was a affirmative defense, 6 affirmative defense. We move for cross motion just on that defense. There's nothing in the policy. And I think the case that's really instructive here is the case we cite called.
Well, do we need to, if their affirmative defense was failure to appear and your client appeared, do we need to get to the policy to decide that affirmative defense?
You probably would not, because as a matter of law, the evidence that they present, and I believe under 1.150, the lower court is allowed, based on the factual statements from either party, to rule and say, based on the facts, I can grant summary judgment. We ask that the court go a step further and clarify the legal issue, because we don't want to come back here.
Well, doesn't that mean you're asking us to decide something not pled? Right? They pled failure to appear. You're asking us to grant you summary judgment that you did appear, right? And you're saying that affirmative defense is completely different than an affirmative defense of, like, you know, whether you failed to comply with some reasonable condition imposed. So are you now asking us to decide an unpled issue?
On their affirmative defense, it very well may be, but why we asked it, Your Honor, is because they didn't object to the fact that our avoidance wasn't there below. We argued it. It was argued by them. It was argued, the issue was tried by consent. It's a lingering issue. And what I believe my clients fear, and what I think the parties fear, is that if we say motion for summary judgment reversed because it wasn't pled right, and then there's an affirmative defense that's repled, we're going to have.
But are you asking us to decide the 6th affirmative defense? Or are you asking, saying your client appeared? Or are you asking us to decide the underlying substantive issue that wasn't pled by either party? Which is whether or not your client could record.
I think it's both, Your Honor. I believe that their summary judgment would have to be reversed, or the summary judgment for them would have to be reversed. Because the evidence shows that they failed to appear. Now, we move on cross motion for summary judgment saying we have a right to record. We believe that since they didn't object, the issue was tried by consent, so it doesn't have to be pled. That's been our issue the whole time. And the court can take that step if it wants to, because the issue is tried by consent. It doesn't have to,
Well,
but what I,
we're beyond,
Yeah.
you know, the point of whether or not you can record an examination under oath in this case. It's, you know, now we're, you know, a lawsuit's been filed and that lawsuit will proceed. Why would we address that issue that's gone? It's academic at this point, assuming that we agree that that there's a difference between not appearing and the conditions under which the examination under oath was going to proceed.
well, that may be the issue that the court has to shake out, is whether a failure to appear, what we saw in the answer brief was failure to appear. The argument then became, which we objected to, or we noted in the reply, became failure to submit. And what we pointed out in our reply is submit and appear are two different words, mean two different things.
Yes, you argued that, and you started your argument today with saying they're two different things. That's why we're entitled to, you know, that's why the court shouldn't have granted summary based on a failure to submit when what they pled was failure to appear. And then your next thing said, but even though they're completely different, and our argument is they didn't plead failure to submit, decide failure to submit. Do you see the inconsistency there?
I understand. It's solely for the purpose of, if this court finds that submit is appear, that
You're arguing in the alternative.
in the alternative.
Okay, so if we decide that failure to submit is not failure to appear, we need not reach whether failure to submit occurred because no one pled it.
Nobody pled it, Your Honor. I would agree with that. To the extent that the court doesn't agree, we believe that the policy is clear, it's silent, and that the Nawaz case out of the 4th DCA, NAWAZ, makes clear that if the policy is silent, the tie goes to the insured.
Okay, if we're assuming appear and submit are the same thing,
Yeah.
big assumption. The statute says that appearing, submitting, complying, I think it says, is a condition precedent to receiving benefits. What gives the insured the right to set conditions to complying with that condition precedent? Here it was recording. But if it was a different kind of condition, when it's the insured's duty to comply with and meet the condition precedent?
I would cite to this court Allstate Floridian Insurance versus Farmer, which is a 104 SO3D 1242 out of the 5th DCA. It's an opinion written by Judge Cohen. And
That might be a mistake.
Can you get the signing at 104 7 3rd what?
104 SO3D 1242. And just in passing, Judge Cohen's opinion said the courts require there be at least substantial compliance with condition precedent, which means it's got to be a question of fact whether the compliance was reasonable. The lower court said, well, the statute doesn't have a reasonableness compliance, so anything that the insurance carrier puts on you. Remember, the powers of the insurance company are defined by their contract. And that's what Nawaz says. If you want to prohibit me from videotaping, you wrote the contract, add it. Nobody's saying that Progressive can't stop me from videotaping.
Counsel,
If they write,
if this case results in an opinion that reverses me on the 5th, I'm going to hold you responsible personally.
well, Judge, I would say this before I run too far into my rebuttal. I think if that is the case, you will have the unique distinction of making precedent against yourself. So that's something.
Well, I didn't say I was going to.
It's something to consider, but I see that.
I think it was a very well-written and well-reasoned decision.
I mean, I thought it was. Briefly, I would say that, yes, I agree with the court. They are two different things. In the alternative, we believe the contract doesn't prohibit us and that the insurance carrier can't add the prohibition after the fact, and the work product argument. It doesn't hold water when counsel for the plaintiff is in the room. It's a categorical waiver, and they didn't raise it in their answer brief. They didn't even respond to the argument.
Was that doesn't cold water. Was that from my cousin Vinny? Is that where you got that?
I'm not sure. I know that my suit is of appropriate. Thank you, Your Honor.
Good morning. May it please the court. I'm Ken Nazari here for the Appalachian Progressive American Insurance Company. I'd like to kind of go in the order that questions were raised, if I may. Judge Cohen, you rightly pointed out that this was not a situation where the insured sought the video
Does that mean
tape
you're
herself.
not going to start with my cousin Vinny?
No. It's been a long time since I've seen that. I don't want to misquote it. And I don't think it's a fact.
So you haven't seen it at every single CLE you've ever attended?
It's been a while since I've been to a CLA too. So at any rate, and this is completely unacknowledged in all their briefing. They continuously say that Ms. Weir sought to bring her own recorder and record. That's not what happened. Mr. Ovadia.
Does it make a difference who brought it?
It does, because he's setting a.
If she'd have brought it, would you have let her, your client have let her do it?
Well,
If she'd have just picked up her cell phone and said, I want to record, I'm gonna hold it while we're doing it, would your client not have an objection?
I don't know the answer to that question. There's nothing in the record to.
Well, you
answer
said it would be
either way.
different.
Well, what we have is in the record is Mr. Ovadia insisted on bringing
That's a
video
fair
camera.
question. Judge Mice asking a fair question. Would it have made a difference? If so, legally explain why that would have made a difference.
Okay. So, even though it's not in the record, she wants to record on a cell phone.
Yeah. She
Okay.
says, hey, I'm gonna put this, got a little cell phone stand here. I'm gonna put this here. Go ahead, ask your questions.
Okay. I guess that would be up to Progressive to decide how to handle that. I think that's a more reasonable request of the insured, because there's a court reporter apparently probably with a recording device there as a backup to the stenographer. So I don't think that impedes or impinges on what's going on here.
Okay.
Whereas a video of Miss Groves could be taken and put up on the internet. It could be circulated to all the plaintiffs' bar.
So the insured can record, but the insured's attorney cannot. That's the rule.
Pointing the camera at Ms. Groves. He imposed that condition. And this gets into what Judge Wozniak raised is insureds and their attorneys especially can come up with any number of conditions. In Curran, they talked about the laundry list of conditions. So how many conditions can the insured put on this? We would submit either little or none. You've raised, you're going to the absurdity.
Is your problem with it that it can be posted on the internet?
That's part of it, sure. It can be used to make mission.
But they're entitled to get a transcript. And so if they wanted to post that on the internet, that could be posted on the internet.
Well, that gets into the work product issue, but I would submit to you, it's different. That a cold paper transcript is
But
different
you
than
said,
video.
your client said she could have a videographer. And if she hires a videographer, she's got a right to the video, doesn't she?
Well, we would submit that there's still work product until a lawsuit is filed and it's requested.
Answer the question I asked. Your client agreed she could have a videographer. If she hired a videographer, she would have the ability to get the video from the videographer, correct or not?
I think that's a fair statement.
Okay, so you would have a third party with a video under your client's, what your client concedes, you'd have a third party, the insured, with a video with no legal restrictions of any kind on her ability to broadcast that video or transfer it to third parties, correct?
Yes, with one important distinction, if I may.
Go ahead.
The video would be of the insured giving the EUO, not of Ms. Groves
Okay.
asking questions and taking.
But the question, well, first of all, you can tell a videographer to point the camera at whoever you want,
I
right?
don't agree with that. I've never seen that happen in a deposition or an EUO.
In either case, the questions are the audio of the questions is available, correct?
Yes, Your Honor.
Okay. So can you tell me any circumstance where items are privileged, where third parties have copies and have an unfettered legal right to distribute those to the entire world, and some other party claims those documents held by the other party with the right to distribute widely are privileged?
I can't think of another situation.
Okay, so we'd be the only court in the history of the world to find that?
No, Your Honor, because the camera.
Well, you just told me there's no other
But
court.
the camera was pointed at Ms. Groves. The record is undisputed on that.
So
So that's a different situation, Your Honor.
Hold
That's
on.
an intimidation and harassment.
hold on, Counsel. Work product means privileged, right? Privileged means you have a right to keep it private, does it not?
Yes,
Okay,
under
okay.
certain
Do
circumstances.
you
yes.
know of any circumstances where there's privileged information that you don't have a right to keep private?
No, Your Honor.
Okay, so this would be, you concede, information that a third party has, right? And at least a video with the audio of your client's employee speaking. And she would have an unfettered, she would not only possess it, but she would have an unfettered right to distribute it to the entire world. And you're saying that's nonetheless privileged.
Your Honor, that goes to the work product issue. If we
But
could-
counsel, and I'm asking you to
Okay.
answer the issue.
Yeah, okay,
Work product is by definition private, is it not?
it is.
Okay, would this information be private?
Your Honor, no. Your point is well taken. If we're talking about an audio recording by with a cell phone.
Okay,
Or a professional videographer hired by.
so
hired
even
by-
though you admit audio of the exact same proceeding would not be privileged, you're saying that if the camera is pointed at your client and that not only is there audio, but there's video, that makes it privileged?
No, well, Your Honor, the work product issue, which you are hitting on, is challenging no matter any way you slice it. Okay, but the work product is a separate argument that we don't have to prove that it's work product to prove that this was improper and set an improper condition on the EUO. The plaintiff was not
Are you
entitled to have,
Are you withdrawing the work product argument?
you know, it's got some challenges into it as.
That's
we're
a year, yes or
pretty
no,
much
are you
as much-
withdrawing it or not?
Counsel, answer the question.
Okay, we'll withdraw the work product. Okay, so let's focus on the conditions then. Mr. Ovadia comes in and says, she will not give her EUO unless I can point the camera at Ms. Groves and record her during the EUO. The question is, did he have the right to put that condition on her submitting to an EUO? Under 6G, which is what governs this and which makes it different from Nawaz and Allstate Floridian and all the other cases, they had no right to impose that condition on the EUO. She was required to submit.
Wasn't it really progressive that was, imposing the condition by saying, well, if that's what you do, we're not going to take this examination under oath?
No, it was Mr. Ovadia imposing the condition because he said she would not give the EUO unless he was entitled to record Ms.
Well, counsel,
Groves
so
during it.
isn't that one of the ways to frame it is who's imposing the condition, right? You could frame it as she and her counsel's her agent, right? So that's her saying, I want a camera. You could also phrase it as your client imposing the condition of no cameras, right? Like say you took it to something else, say your client said no cell phones in the room, right? Because they might be recording and we think this is private or confidential in some way. You could look at that as her imposing the condition of no, I want to have my cell phone on me. You could also look at it as your client imposing the conditions of no cell phones in the room. Why is the proper way to frame it that she's imposing the condition as opposed to your client?
Because she's the one, they set the EUO. The EUO is set. Okay, she's supposed to come in and answer questions.
And
pursuant to
Progressive set the examination under oath.
I'm sorry,
Progressive set it.
Progressive sets the EUO
Right.
as it's entitled to do under the policy and under 6G. And then the response is from Mr. Ovadia on behalf of his client, she will not give the EUO unless I can record Ms. Gross. That
And
is
you're-
him setting the condition. That is not.
Yes,
Progressive
and your
setting the
client
condition.
got there and said, we won't take the EO if there's a camera.
Correct.
So you have one party saying, I won't do it without a camera, and you have one party saying, we won't do it with a camera. So we have to decide which of the two parties is imposing the condition, or at least we may have to decide which of the two parties is imposing that condition. Why is it proper to say it's them instead of you?
Because they insisted on it first. They said she would not sit unless
So
he could record Ms.
really,
Gross.
Maybe what we need to do to decide this case is to go out to a playground and watch 6-year-olds.
Your Honor, when this case got moved to Law Day, it wasn't my favorite appeal to come argue.
Okay. Fair
Just
enough.
being totally candid with you. But the fact of the matter is, what has she said, we said in our briefing, I will only sit unless it happens in Alaska. I want to go to Fairbanks, even though I live in Florida. I could think of any number of conditions that she could say, and then if Progressive pushes back.
Answer the cell phone. So she walks in and says, just so you know, I've got my cell phone. She puts a cell phone on the table and she walks in so she can see if she gets a text message or something. And your client says, nope, you got to leave the cell phone outside. We've got a cubby. We can't have any cell phones in here. Who's at fault there?
People carry cell phones with them everywhere they go.
And cell phones have cameras.
Well, that wasn't the example you just gave me. You just said she brings it in with her because she might get a text.
But who's
So
imposing the condition in that circumstance? Is she imposing the condition
She's
of I
not.
have to have my cell phone? Or is your client imposing the condition of you can't have a cell phone?
she is not imposing a condition by bringing her cell phone into an EUO
Okay, but if she brings a camera, she is.
and points it at Ms. Groves. Yes, her attorney does that. Yes, absolutely.
So it's not the camera, it's just where the camera's pointed is the only, that's the whole distinction. Your case rests entirely upon where that camera was pointed.
Well, since we agreed to it being video recorded, if it was done professionally, yes, that's a material distinction. And it all goes to, can the insured insist on that? And then be relieved from the duty to sit for an EUO if the insurance company doesn't agree to it.
Counsel, I agree as a factual matter, it's based on the, what your client agreed. If they agreed there could be a videographer, and the only difference with this, we pointed there. So as a factual matter, the case, the material fact is where the camera was pointed. What legal doctrine could we possibly say is contingent on where the camera was pointed?
What legal doctrine? I'm sorry, I don't
Yeah,
understand the
like
question.
how could we decide this case in a way and say she wasn't allowed to point the camera at the progressives representative, but she would have been allowed to point it anywhere else and she could have a camera in the room? What legal doctrine at issue in this case could turn on that fact?
Okay, so Your Honor, first of all, you don't have to go to facts that aren't the record, which is the hypothetical facts you're proposing to me. The
No,
legal-
it is in the record that your client allowed a videographer. That is in the record,
But
counsel.
Your Honor, your question was, how can we do that when she could bring a cell phone in and record herself or something like that? Those
No, but the
are facts of
videographer
this
part's in
case.
the record. It is in the record that your client, Elap, was permitted her to have a video recording of the session as long as it was not pointed at your client. And you just said in answer to Judge Cohen's question that that is the material fact where the camera is pointed. So don't tell me it's not in the record. It's in the
No,
record.
that's in the record, Your Honor.
So if the material fact is where the camera was pointed, what legal doctrine at issue in this case could we say hinges, the resolution of which hinges on where the camera was pointed?
6G. 6G. She has to submit to an EUO as a condition preceding to receiving benefits. She is not entitled through her attorney to say, we will not, you can't create an exception to that statute that says, okay, if the attorney insists on recording progressive's representative during the EUO, that creates an exception to her duty to sit for the EUO under 6G in the policy. That's the legal doctrine. Under the facts of this case that are undisputed, that her attorney, Mr. Ovadia, would not allow her to give an EUO unless he could point the camera at Ms. Groves, which serves nothing but to harass, intimidate, to try and get a video to put on the internet and circulate into the Florida bar. 6G does not allow that exception. That is the doctrine that governs this case under the facts of this case that are in the record.
So given the discussion about who imposed this condition and all of that, are there avenues that the insurer could have pursued petitioning the court or something to get a ruling as to how the EUO could be done instead of sitting back and waiting for the lawsuit to be filed, raising it as an affirmative defense?
I suppose a deck actually could have been filed, but.
Isn't there another subsection in the statute? I think it's subsection C that mentions an insurer being able to petition a court if there's, I think it says a dispute regarding the right to discovery.
That relates to documents that have to be produced
Okay.
under 6B. I don't believe that relates to an EUO.
Okay, so there's nothing that could have been done then?
Other
Aside
than
from waiting
filing,
for the lawsuit?
affirmatively filing a deck action, I
Okay.
guess, Progressive could have done that. Other than that, I'm not aware. I do want to address the issue of the summary judgment and the waiver issue that Judge Mize asked most of the questions about. This case falls squarely under the Reddy and Ming decisions from the 5th DCA, of which at least two of you used to sit on before. In that case, there was defenses that were not raised or in actually a cause of action there were two promissory notes in Reddy. The cause of action was brought on the first promissory note. And then at summary judgment, the plaintiff moved for summary judgment on a second promissory note that was not pled. It was not part of the pleadings. And the defendant came and didn't argue this isn't part of the pleadings. They argued the note wasn't due, the second note. So they accepted that argument. Similar set of facts in Ming. And reading from Reddy, it says, once appellee shifted his focus from note A to note B, appellant should have objected or argued that appellee requested the trial court to rule on issues outside of those framed by the pleadings. Instead, appellants argued note B was not effective, as if the appellee properly pleaded note B in the complaint. By arguing whether a genuine issue of material fact existed as to note B, appellants waived a challenge to whether note B was the operative note, and whether the default under note B, if properly pleaded, was premature. That's exactly what happened in this case. In their own motion for summary judgment, we quoted it on page 11 and 12 of our answer brief, and it's found at page 358 of the record. They lay out all the facts of them going to the EUO and wanting to video record and Progressive not agreeing to do it. And in response to those, Progressive argued at the summary judgment hearing. So those facts that were raised by them affirmatively in their motion for summary judgment.
Can you respond to your opposing counsel's response to the waiver issue about record page numbers 1008, 1009,
Yes.
the argument made at the hearing?
Yes, as we said in our brief, what happened there, and I have it as 1216 and 1217 is the transcript that I'm citing from when I was looking for it. Mr. Casper said all they pled was failure to appear. He was the trial counsel, Mr. Casper. And he said, that's blatantly false. That's blatantly false. And that's what Mr. Ovadia said in his affidavit. So he wasn't arguing that there was a new theory being asserted by Progressive, because they had asserted the same theory in the motion for summary judgment. He was arguing what he accepted that affirmative defense, and he said it's blatantly false. So he was trying to, even though their own motion for summary judgment argued the facts of them showing up at the EUO and everything that happened, although we don't agree with the way they characterized the facts, he was trying to hold Progressive specifically to that language.
How are those inconsistent, right? So if they point out, hey, their affirmative defense, judge, only applies to failure to appear, and we did appear, look what happened at the hearing, we appeared, and yes, there was this dispute about all these things. How is pointing out what the real dispute was inconsistent with saying that dispute is something different than what they pled? Don't you have to discuss what the actual dispute was to point out that it's different than what was pled?
No, Your Honor. That when they did that, put the case squarely with him, Reddy and me. What he should, if they wanted to make this argument, Mr. Casper should have shown up at the hearing and said, the affirmative defense says failure to appear. Okay, they can't make it that the facts show that we appeared, period. So they have waived, or they have not pled any other defense to it. And any argument that there was a failure to submit based on the facts of this case is not pled. And he should have raised the pleading issue right then.
So you're saying that if they interrupt the lawyer and say, well, wait a minute, you can't do that. That's what you have to do instead of waiting until that lawyer finishes the argument and saying, Judge, that's a different argument than they raised at the motion for summary judgment.
No, Your Honor, you don't have to interrupt the argument. You have to make the pleading argument.
But counsel, they did make the pleading argument. They then just went on to say, and this other argument we're making they think is wrong. So you're telling me if they tell the judge, they didn't plead that, but even if, we don't think you should consider it, but if you're going to consider it, it's wrong. That by doing that, they waive it?
It's in their motion. They argue the facts in their motion, their own motion. Everything we're here talking about, they move for summary judgment on those facts to say that Progressive could not, deny benefits based on what actually happened at the UO. They inject the issue into the case through their own motion for summary judgment. If they would have simply said this whole argument that Progressive's making, that she failed to submit because of the video camera being pointed at Ms. Groves isn't pled, and therefore it's improper under summary judgment, that would have been the way to preserve that. And stop there. You lose, Progressive. You didn't plead it. We don't have to go any further. They affirmatively injected the issue through their own motion for summary judgment.
But counsel, if your client is arguing they didn't appear based on a failure to, based on the fact that they imposed this condition, and they want to argue that we didn't fail to appear, my client was there, and she's right about all these things, and she didn't fail to submit. Don't they have to talk about what the underlying dispute was in order to point out how it's different than what was pled?
I think that's a fair point, but the argument should be, which was never made, that it was waived. It's been waived because it wasn't pled. That was never said by Mr. Casper at the summary judgment hearing. It was never said. Okay, it was raised on a motion for rehearing, which
He's got to use that magic word.
you have to make the argument, there's a waiver, Your Honor. You can't not make the argument, okay? And this is important because footnote 6 of Reddy says, if appellants had objected, appellee could have amended the complaint to include a cause of action under note B. Appellee could have done so as late as a hearing on the motion for summary judgment through an ore tennis motion. So if the argument is made, which it wasn't, there's an opportunity to move to amend to add the affirmative defense, to supplement the affirmative defense. So there's actually prejudice here when they don't make the waiver argument. Instead, they argue the merits based on what everybody agrees the facts are. They argue the merits, which puts it under Reddy and Ming. And by the way, we argued Reddy and Ming in our answer brief, and there was no response in the reply brief to those cases because they are directly on point. They accepted the facts of the case, the theory of the case. They argued in their motion.
Okay, thank you.
Based on that, we ask you to please affirm. Thank you.
Your Honors, briefly. With regard to the summary judgment issue, I also want to point out, because it was cross motion for summary judgment, and Florida law doesn't really address this yet, so it's a new issue.
I'm just going to interrupt you really quick. We're having issues with the timer, and so I'm going to be giving you 4 minutes, and I'm going to be doing it from my iPhone as my backup.
Okay, I thought it was just counting up to 20.
Don't feel that you need to use.
So, yeah,
Yeah, don't rely on the light. You've got 4 minutes.
yes. Go
Very
ahead.
briefly, because it was a cross motion for summary judgment, we would believe that 1.150C5 says these arguments still have to be raised if you're responding to my cross motion 20 days before hearing. Can't do it at the hearing. So there's a procedural flaw there. With regard to the location of the camera, and I know that has been hotly contested, but I'll say this much. If you go back and review the EUO transcript, there's no objection to how the camera's facing. This all comes out after the fact. It comes out of summary judgment hearing months later. Oh, yeah, well, the camera was facing towards Ms. Groves, so that's why we objected. Well, you have to make a contemporaneous objection. And the contemporaneous objection they made at the EUO didn't say who it was pointing at or what it was pointing at. And
In your reply brief, did you address the issues or the cases that were raised in terms of the last issue argued by the appellee's counsel?
yes, we didn't address Ming directly, say, hey, Ming is distinguishable for X, Y, and Z. Let me point out, sorry, where our point heading is. I would direct the court to regarding the waiver issue. Advance did not, our argument 1C, advance did not have to assert its waiver argument via reply. Regardless, Progressive tried the issue by consent. At a minimum, Progressive's answer brief demonstrates a question of fact. Argument 1D, Progressive cannot amend its sixth affirmative defense via argument in response to advance cross motion. Those are issues directly related to those cases, though we don't say the case is distinguishable. We cite the law, we cite the rule.
Okay.
And briefly, there was talk on rule 736 or 737, 626, 6G as this is the basis. The problem with that argument is, that statute doesn't say my client has the right to counsel at an EUO. Doesn't say my client has the right to a public adjuster if it was a property case. Doesn't say any of those things that we know are allowed. And they're allowed because the relationship between an insured and an insurer is the document, is the contract. And they wrote the contract. And if they want to prohibit something, they have the right to. And then the Waz court said the courts will not rewrite the contract to add a condition that you could have added, Progressive, as the author. You didn't add it. You can't ask us to add it after the fact. And even if it was somehow ambiguous, tie has to go to the insured. It doesn't go to the insurer. And for those reasons, we'd ask that the court reverse the granting of summary judgment and actually affirmatively grant our cross motion to the extent it believes there's an alternative basis to submit and appear are the same. Thank you.
Thank you, counsel. So we have one more case after this, but at this point, we want to go ahead, if council are available, to introduce themselves to the students and any questions that the students have to council about their case or about their background, any advice they have, please feel free to ask. We'll wait until after the next case for the judges to introduce ourselves and to take Q&A from us, but we don't want council to have to wait for the whole next case. So whoever wants to start, go ahead.
Hi, my name is Jeff Molinaro. I'm a board certified health practitioner. Most of my practice is field trial support. I do some regular civil commercial litigation as well. I went to Florida undergrad and I went to FIU College of Florida for law school. And I'm happy to be here. And my nephew, my UCF, or my son is on the night. I'm Ken Missouri. I'm also board certified, board certified in practice. I'm practicing law about 7 years. All myself a commercial litigator, which means class and
Right there, up and down.
this, it's founded in insurance. I do focus the majority of my practice on DOT today. That's what brings me here. So I'm happy to answer any questions. Do you want me to call it? Do you want me to call it?
They put up their hands at the same time, so you pick. Go ahead.
Your vote.
Well, it was interesting hearing both sides. I just had a little bit of difficulty following along. I heard the term CBO keep coming up, and I'm assuming that that means examination in the road, correct? So what was the issue with it that the camera pulled it on the client as it wasn't supposed to be, and then that the audio was very full.
Why don't you start by explaining what an examination on the road is?
It's not ex parte, we're all here.
Yeah.
Yeah, go for it.
So what happens is when there's a claim under the policy, Ms. Weir was insured here, she got in a car accident, she had a claim for what's called PIP coverage. If the insurance company has questions or concerns about the claim, they can set the insurance what's called examination of the road. The insured is exactly what it sounds like, comes in and is sworn in and answers questions about the claim. And that's provided for what we call PIP statute, which governs PIP law. So in this case, what happened was the insured had an attorney. The attorney insisted when she came in to provide her EO. When say it, he insisted on pointing the camera at the progressive representative, his own camera, progressive representative, who would be taking the progressive to issue that, so they would not allow that to happen. And so the EO did not go forward. And then progressive ultimately did not deny PIP coverage for the claim. Mr. Romero represents the medical provider who treated the year and the PIP benefits under the policy, so they're challenging the denial.
Now, does the EO function similarly to a definition of the authorized by the court?
It is somewhat similar in format, in that there is a person answering questions in the definition of the policy component, in the examination of the called insured, pending. It's a similar format, but because the EO generally almost all the time has to help outside of litigation, there's a large movement of the procedure. Government deposition being used, but tell us how it's supposed to go. There's nothing like that in the so it's a little bit more ad hoc. There's some law and understanding based on law. Until I see what governs the process, I would submit on how EO should be conducted because of rules that govern them, and not a whole lot of this stuff. And I would say this much.
Those online and not here.
I would say this much too. Though this case involves an accident and PIP, what you hear with the lawyers and what you'll find if you go to law school, you go into legal practice, what Ken and I are really arguing about is, and what you heard the judges speak on, is what does the law say or not say, and what does the actual agreement between Ms. Weir and Progressive say or not say. And what both sides are arguing is who has the right to either modify terms that are silent? How do we interpret things that aren't there? Where does that tie go? Can someone add a condition? Can someone deny a condition? Back and forth. And that's really a paper document. So, the story, I try sometimes to say the sexy story that brings people in, the court TV thing is, oh, there was a car accident, somebody was injured. And that's really trial work, right? When you're in front of a jury, you tell that story. And, oh, she was injured. And look, this big bad insurance company isn't paying her bills. And how dare they? And the argument on appeal is much more refined. Hey, does the contract provide for sitting for an examination with a video camera? It's literally, yeah, exactly, or the statute.
No, not at all.
Repeat, one aspect of that is.
Hold on, let them repeat the question. Yeah, restate the question, please.
Right.
So the question was, how do the attorneys keep themselves composed? I'm paraphrasing, but how do the attorneys keep themselves composed when they're being asked difficult or hard questions by the court?
I was just gonna say one aspect of that is the asymmetry. We read the briefs beforehand. We know what we're gonna talk about. We get to decide the questions and we know them in advance and they don't. Right? So it's much harder on that side of the table. I think.
Go ahead.
I think part of it is, part of anything is repetition. You practice, if you noticed, I had notes, I brought my notes up, I brought this up, I kind of call it my pacifier. The process of making it is what gets you prepared. I coached college football before I went to law school, and we used to have the saying, you inspect what you expect. So you put in the time and effort, and you can see my colleague Ken has the same thing. He has notes. Those are how you prepare, but you're never going to know all the questions that are going to come at you. You can anticipate what's going on. So that's how one way you prepare. The other is, I find, and why I'm drawn to appellate work, is the format is much more collegial. I have worked with Ken on other cases. He's wonderful to work with. This was a tough case, I think. And you know what's coming. And when you act professional, you get professionalism back, and the bar appreciates it. And the appellate bar in Florida is very professional, which really makes your ability to understand. And the third thing, I think, which is something young lawyers have to remember, and it's good for any business people, is this is not personal. They're not asking me questions because they don't like me or because they like me. It's not personal. So these are criticisms of your argument. They are constructive criticisms. They are pushing because they make law. That's what we do in a common law society. The law always evolves with open questions. So when you come to an argument with that mindset, my opponent is not my enemy. The counsel or the court is not my enemy. This is a collegial environment. We're here to solve a problem. And it is constructive criticism of your arguments. I think that's one way to stay cool under pressure.
I agree with everything that was said by both Judge Mize and Mr. Molinaro. What I will tell you is, echoing what Mr. Molinaro said, in all legal practice, appellate or trial work, and especially, I'm going to kind of go stream of consciousness here, especially trial work, because trial work, you're going into a trial and there's going to be evidentiary objections, and you got to try and account for everything that's going to happen during that trial, sometimes thinking on your feet. As the gentleman said, for those who were here before, in appellate world, most of the work is in your rearview mirror. You've got a record that you're working from. And so you don't have to anticipate what may come as much, except at oral argument. And I have to say that as much as you get prepared, it's a rare time in an oral argument when I don't get asked a question that I wasn't expecting. And that happened today too, probably on multiple occasions, despite all my preparation. So the key to everything, for being a lawyer especially, but also in anything you want to do in life, is preparation, in my view. Mr. Molinaro said he was a football coach. The quote that I love regarding this, which is from John Wooden, who's kind of universally recognized. I know you guys are a lot younger. He was the coach of UCLA for 10, 15 years and won like 10 national championships in a row in the 60s and 70s. And his quote, if you take it to heart, it'll take you a long way, is, and make sure I get it right. Failing to prepare is preparing to fail. That's the bottom line. And it doesn't mean you're going to succeed if you prepare, but you certainly have a much better chance if you do prepare. And that's the key to everything. As far as staying composed, preparation, if you come in and you know you're prepared the best you can be, that helps a lot because it takes away the anxiety. If I came in unprepared, I would have been a lot more nervous than I was, I promise you. So it's really the preparation that gives you that foundation. And then just recognizing that everybody's trying to get to an answer here. It is a question and answer. The judge's job is to probe our arguments and the weakest part of our arguments, which I submit there was a good job of that done today. And that's just part of the process. So you try not to make it personal. And I do agree in the appellate world, you get to work. It's a lot more collegial than the trial world, just in general. And you get to work with people like Mr. Molinaro, who it's always a pleasure to work with.
Thank you.
Great, we're gonna have to move to the next case, to stay on time, but as a testament to the professionalism and collegiality of these attorneys, they were supposed to go on Thursday for their oral arguments, but we had a dismissal of a case that was supposed to be today, and they both agreed to come 2 days early, to present in front of you all today, so we thank you for that. And with that, we'll move on to the next case.
And while the attorneys are coming up, all of us up here have done, appellate work before we became judges. And the worst thing you can have happen to you at an oral argument is to have a bench that asks you no questions. That's just a nightmare for a lawyer because you have no idea what the judges are thinking. And I know when I did appellate work, I never prepared a written argument because I knew I wasn't going to have any time to do it. I was going to be, hit with questions. So really, having a bench like, we're a fairly active bench, but that actually makes the job easier for the lawyers, not harder.
Thank you.
Thank you, counsel.
The next case is 23-675 City of Winter Haven versus Winter Haven Professional Firefighters Local 4967 IAFF. Counsel, if you need a minute to get situated, we can give you that.
Thanks.
Sure. We ready to proceed?
Yes, Your Honor.
Okay. How much time would you like for rebuttal?
5 minutes,
Okay, thank you.
maybe 7. If there's, but we'll see, I'll reserve whatever I have. So I'll jump right in and say, again, may it please the court. I'm Greg Hearing from Gray Robinson. I represent the city of Winter Haven in this labor arbitration appeal. And this, presents a unique question for this new DCA, one that has been looked at by 2 other DCAs. But when an arbitrator is under the Florida Arbitration Code, makes a decision that involves going outside the record, has that arbitrator engaged in misconduct or exceeded his or her authority?
Let me start with perhaps a little bit more basic question, which is this not the equivalent of a second-tier cert? You had an appeal. This case went to an arbitrator, and the arbitrator ruled in favor of the firefighter and the union and against the city. And so you appealed that to the circuit court.
Yes, sir.
And had a full appeal there. And the circuit court ruled against you on that appeal.
That's correct.
And so now you come to us. And you don't get, you would agree that you don't get a whole new bite of the apple, right?
Well, the standard is de novo review, Your Honor,
To know a review of what?
of the arbitrator's actions with regard to whether under chapter 682.13, he engaged in misconduct or exceeded his authority.
So not review of the circuit courts, which was admittedly limited as well. So not a review of the circuit courts, limited review of what the arbitrator did. We're going back to square one to what the arbitrator did.
Yes, as on the questions of law, whether he exceeded his authority.
Okay.
And I understand judges are loath to go and look into arbitration results. And you all especially had a second
Because
here.
it's supposed to be a final,
Yes,
there's
sir.
finality. That's the
But-
whole point of it.
But that assumes that due process was given to both parties in that process. And the essence of our appeal is that this arbitrator in his award, without giving any notice to the parties or an invitation by the parties, took arbitral notice of his view of society's tolerance.
In your
of
brief, you
everyone else.
focused, you gave the analogy of 9202 and, you know, the requirements to take judicial notice. I noticed you didn't cite 9201, right? So there's certain things we take judicial notice of all the time without notice, right?
That's
So for instance, the reason we can all, you know, refer to the same statutes without having to decide what are the, you know, what is the accurate statute is we're entitled to take judicial notice of statutes.
Yes, sir.
When you're a trial judge in the middle of trial, right, if there's a statutory issue or you need to see statutory language, you're permitted as a trial judge to just pick up the statutes. You can take judicial notice of Florida statutes, federal statutes, cases from other states, right? You can take, we can't judicial notice of the case law from Arizona. That's why when we look it up on
Yes, sir.
Westlaw, we don't have to go through a notice and period to the parties. We can just say, hey, here's the site from this court in Arizona. Would you agree with that?
Yes, sir.
All right. So that's 9201. Okay. You can't take judicial notice of foreign law. Okay. You can't take judicial notice of law of England. And there's a procedure when you need to establish foreign law if it's disputed, actually, right? And there's case law on that. It can actually be a factual dispute because there's no, you know, if you're looking for the law of China, there's no Chinese Westlaw, or it's, and just the statute doesn't allow us. There might be a legitimate dispute about what is the law of record in a particular country.
That's correct.
Okay. So you can take judicial notice of certain things without notice of the parties, and there's nothing improper about that. You can't take judicial notice of other things without notice of the parties. If you showed up to a hearing, okay, and the trial, there was some issue of English law, okay, and the trial judge took judicial notice of an English statute, which you cannot do. Okay, we didn't know that. Judge just was wrong about 9201. He thought it included, he thought it included common law countries or Western countries, and it was just mistaken. So he took judicial notice of English law. Unequivocally, that was a mistake. Was it a legal mistake or was it misconduct?
It was both.
So the judge, the trial judge in our case, who just thought genuinely that you could take judicial notice of English law, and he did that. It's not just a legal error. You're saying that trial judge committed misconduct?
Well, under this statute, if this was an arbitrator, which says specifically what misconduct is, and that's going outside the record.
But counsel, I really took issue with that in your briefs because I think it was completely wrong. Judicial notice by definition doesn't involve record evidence, right? So I think the Quezada case you relied on, the arbitrator in that case called somebody, went outside the record, okay? And what you said is, well, this fact wasn't in the record for the court to take judicial notice. Judicial notice by definition is something you take notice of without evidence, inside or outside the record. It doesn't involve being inside the record. It doesn't involve being outside the record. That's what judicial notice is by definition. So to say that the arbitrator went outside the record, judicial notice doesn't involve the record or being inside or outside the record. By definition, judicial notice is noticing a fact without evidence.
Respectfully, Your Honor, this arbitrator didn't go and have judicial notice of some law or what's in the 101. What he did was something that is social mores, which you have to give parties notice and opportunity to be heard on that.
Counsel, I take your point that that was a legal mistake, right? And that, the trial, you say the trial judge shouldn't take enough judicial notice. But what you said is something different than that. You said he went outside the record, right? You analogized it to Quezada. And what I'm saying is not only did he not, right? He didn't look to any other party, but judicial notice by definition doesn't involve evidence inside or outside the record, because that's what judicial notice is. It's noticing a fact without evidence of any kind.
Well, no, that's not true. That in terms of 202 and 204, there's other types of judicial notice, and that's what happened.
I think you're missing the point. The point is, if there is evidence in the record, because you're saying, well, he went outside the record.
That's right.
If there's evidence in the record, you don't need to take judicial notice of it. It's already in evidence.
Well, that's of course, but there was no evidence here of societal
But
views.
the point though is that it's a legal error that's involved here.
Yeah,
It's
Judy-
not, you know, I mean, under your theory, we should be reporting this circuit judge to the Judicial Qualifications Commission because he, committed some grievous offense.
Well, I appreciate that this is first not a circuit judge. This is an arbitrator that the parties
It
contracted.
went to the circuit
he's
court now,
bound.
and the circuit court ruled in your favor.
But he's bound by chapter 682.13 to follow the Florida Arbitration Code. And in Quesada, and Sabatis is a case that you referred to, Judge Mize, that's where a phone call was made by a secretary about something that was already in the record. In Quesada, which comes from the second DCA, which also was a fire rescue case, where a firefighter tested positive.
But counsel, I
The-
read Casada. It doesn't involve the issue here, right? Judicial notice by definition involves taking notice of a fact outside the record. That's what judicial notice is.
With notice to the parties, Your
Okay.
Honor, and there was no notice here that that was gonna happen for this city. And neither to either side. In fact, we would have put on evidence of what society's.
If you're saying he didn't follow the procedure for judicial notice, that's fine. That is different than saying he went outside the record. It's fundamentally different. Judicial notice always involves a fact outside the record. That's what it is.
I can accept that, Your Honor. I need to.
Okay,
to
so
focus
this-
on
But
how
but that was the basis for your misconduct charge, was that he went outside the record.
we exceeded his authority as well, which is also a violation of chapter 682.13. Because by doing that, and
Let's talk a little bit about the, facts of this case. Here you got a firefighter who smoked some pot.
on the
and then,
weekend before he went on shift.
And then a few days later, he's
major
responding to a
accident.
call and apparently doesn't set a brake properly, and the truck, rolls in and causes some damage.
Yes, sir.
And so at that point, he is tested and tests, positive.
Pursuant to the city policies.
Right, and so there's a collective bargaining agreement that talks about looking at whether the punishment fits the crime.
That's the third
effectively.
possible way that the union could
Right,
show there was no
and
just
that's
cause.
really what the arbitrator, seized on in this case. And then the arbitrator says, well, this is a guy who had been firefighter of the year.
Mhm.
He had a spotless record, had never tested positive for drugs, and had been on the force for many years. And the arbitrator makes a decision that the punishment doesn't fit the crime.
And that's
and-
correct.
and-
Right
and the-
before that, Your Honor, you said society's tolerance of
That-
marijuana use.
That's fine,
is increasing.
and sometimes people talk more than they should talk, but it
If-
doesn't necessarily make the decision a wrong decision.
Well, in
And
this
that's
case,
my question to you, is why under the collective bargaining agreement, and when you've got this provision that says the arbitrator can look at the totality of the circumstances, why is that an abuse of the arbitrator's discretion?
well, because he exceeded his authority by doing two things. First, he went and took arbitral notice without giving the parties notice. That's not provided for in the
Counsel, let me ask you this.
CBA.
You got 9201.
Arbitration is a creature of contract.
Counsel, you don't always have to give notice, right? It depends on whether you're under 9201 or 9202. What
That's
if he was just mistaken about where it falls, right? Take the foreign law example. So English law, I think if you were to take notice of foreign law, it falls under 9202, right? You can't do it without notice. There's a procedure if you dispute the foreign law. And the judge is just mistaken. He thought English law, he thought foreign law, common law countries, whatever, fell under 9201. And I take your point. He's wrong. It's legal error. It's a mistake. But is it misconduct?
It is in arbitration. Arbitration, Your Honors, you don't get any discovery in advance. You are assigned an arbitrator who comes in with whatever biases an arbitrator has. The only recourse for the parties is chapter 682.13. And under these circumstances where a first responder, not just general society, this isn't somebody that went to a concert or was a roadie at a concert that smoked marijuana and had an accident and got tested. This is somebody that responds when somebody is injured in life or death situations. And my client did not get the opportunity, if this was pertinent to this arbitrator, to say our social mores here in Winter Haven, in Polk County, under the state of Florida, are that first responders are not going to smoke marijuana. And this
Okay,
agreement,
but
he
you
signed
got
a
a
sworn statement
collective
that you
bargaining
wouldn't do.
agreement. All right, and you can't get away from that collective bargaining agreement. If you wanted to have a collective bargaining agreement that said, period, any test, there's no weighing of whether the punishment fit the crime, and you wanted to put that in your collective bargaining agreement, you could do that.
Well,
And if the parties agree to it, they agree to it, but that's not what the collective bargaining agreement
that's a
does.
great point, Your Honor,
And-
about,
But let me just,
I
go
want to
on.
make sure I comment on that.
all right, and here, let's say that we were looking at what a trial court did. And the trial court made a mistake, but there's all of these other things in the record that supports that the result
It's a
was right.
government.
We would find that to be harmless error. So I just address that for me.
Well, first, so that you understand, and I know Your Honors do, that you all are amazing with the generalist work that you have to do. But with the CBA, that is an exception. That sets forth the rules that the city has to follow. All of those city rules that are not included in a collective bargaining agreement are not excluded. And so the fact that the CBA doesn't say that you can't smoke marijuana.
Doesn't it say the CBA controls when it's in conflict with other city policies? Doesn't the CBA say that?
Yes, but it's not in conflict. It says nothing about that. It
I know,
says-
but it says if you go to arbitration, there's gonna be some measure, like Judge Cohen said, between the crime and the punishment, right? And that the
Sure.
arbitrator will determine that.
And
So the arbitrator's right to determine whether the punishment fits the crime is in the CBA, and the CBA that your client signed says it controls over other city policies.
those are all true statements. And right before that, this arbitrator says, I take arbitral notice of society's tolerance increasing for the use of marijuana. Right before that. And that's just like in Quesada, where the arbitrator there went out and did research and
But-
came in and sandbagged the city.
Are there any meaningful differences in the substance of when an arbitrator can take judicial notice compared to a trial judge? Is there any difference in the standard?
I think it's more important that the parties get noticed because we don't have.
Well, the reason I say that is,
Procedures
if you're,
and things
if you're a
like that.
trial judge and you call a third party, right, and ask about a case, you can get JQC'd, right? That is against the tenets of judicial conduct for a judge to do that, right, as it should be. If a trial judge makes a mistake about whether something falls under 9202, and you relied on 9202 in your briefs, right? That's fair
I
game.
did.
You analogized it.
Yes.
If a trial judge makes a mistake about whether or not something falls under 9202 versus 201, right? English law, trial judge thinks it's 9201. He's just wrong. It's 9202. He should have given notice. There's no JQC complaint. He didn't violate a judicial tenet. And that's my point. When I keep bringing up the misconduct question, you say, well, what this judge did was wrong. It was really, really wrong. And none of that goes to misconduct. Like legal error, even severe legal error, even obviously wrong legal error is not misconduct, right? If you appealed that judge who took judicial notice of English law, you would get an instant reversal. If you filed into the JQC, you'd probably get bar grievanced because he clearly did not violate the tenets of judicial conduct. And you have to show misconduct here. Not legal error, not clear legal error, not severe legal error, not obvious legal error, misconduct.
Under chapter 682.13, 1B3, but under 1D, if he exceeds his authority, it's also reversible and it should be vacated. And he exceeded his authority by going and looking at social mores when neither party asked him to, and that wasn't the issue that was put to him. It was whether the punishment fits the crime. To your question, Judge Cohen. In fact, what that means is that you can't fire somebody for a tardy. But when the city's policies and a sworn statement acknowledged by the agreement are that he will not smoke marijuana, and there's nothing in the CBA that says that, well, you're allowed to smoke marijuana, then he has to enforce that. He can't go outside what that contract is in terms of what he's done. So he's exceeded his authority by doing this. And the city would have put on plenty of evidence about social mores in Winter Haven.
Counsel, what you're saying is he exceeded his authority by making a legal mistake, right? He was not, he
No.
took judicial notice of something he was not permitted to take judicial notice of, right? He didn't follow the right process. That is a legal error.
He exceeded his authority by considering something that the parties didn't put before him.
That is what judicial notice is, counsel.
And you're into your
It
rebuttal
can be,
time.
but it could be.
Counsel, by definition, judicial notice means taking notice of something without evidence. That is what it means.
And I understand that, but it's upon notice to the parties.
Not
And we don't have
always.
a record here.
Counsel, is 9201 upon notice to the parties?
We've established that, Your Honor. I don't disagree with that. It's in the evidence code. But in 90.202 and 90.204, sets forth a specific process. And that's the crux of what this dispute is that he exceeded his authority because he didn't get to take arbitral notice, number one. Number two, he took on the burden of proof for the union. The union, under the contract, is supposed to put on the proof of no just cause, not an arbitrator by making that comment right before he makes the penultimate decision that the punishment didn't fit.
Well,
the
it
crime.
seems you're completely reading out, the subsection 3, the degree of discipline administered by the employer was not reasonably related to the seriousness of the employee's proven offense.
That's correct. And that's one of three ways the union could show that just cause did not exist. And he found that the first two they didn't prove.
Right.
And he found the third one they did based upon his views of society's tolerance of marijuana use.
Right.
And I'll reserve the last 2.5 minutes if I may,
Okay.
for whatever rebuttal. And what other further tough questions you want to ask? Thank you.
Kelly, you may proceed.
May it please the court, Rich Sawicka on behalf of the firefighters union.
Can you address the standard of review issue and whether you agree with appellant's counsel as to what our standard is?
The standard of review in an arbitration case is dependent on the argument that the party challenging the award is. But of course, in this case, we have the employer challenging an arbitrary or a circuit court's decision, and the standard of review would be legal error.
As to the circuit court's decision?
Yes.
And is it the same for the arbitrator's decision?
Absolutely not.
Okay, okay.
The arbitrator, let me jump to that. You lead into that. This is at most the employer arguing that the arbitrator injected a fact into his analysis, which they haven't proven the degree to which it was even used by the arbitrator other than mentioned, but injecting a fact that he shouldn't have. And that being the case, assuming that is true, the Supreme Court has addressed that kind of a problem and said, among other things, that when arbitrators engage in improvident fact-finding, silly fact-finding, tough, you ask the arbitrator to make his decision. And even assuming the arguments fly to any degree, the best of the employer can argue is that the fact shouldn't have been considered. And we don't even accept, by the way, that it's a fact, it's a truism at best.
You don't accept it's a fact that how society views a certain drug?
Forgive me. It is clearly a fact, but beyond it being a fact, it's a truism in terms of.
So you're saying it shouldn't be error because it's a correct fact?
No, I don't think that's even relevant, to be honest. But
You
it
said it.
happens to be a correct fact. But if you you engage in improvident fact finding, you engage in silly fact finding, the courts have said the arbitrator has done what he's done. We do not have anything remotely clear to reaching outside or engaging in improper behavior vis-a-vis the statute.
Would you concede that's where your argument relies on, counsel, is that this was an admitted legal error, but we can't review legal errors? I mean, in other words, do you take issue with the counsel's as to the merits, right? I'm not saying we can review this, but as to the merits, arbitrator took judicial notice of something, didn't follow the procedure, right? That seems pretty clear. So it seems to me your argument, I'm not saying it's a bad argument, but it hinges on, yes, the arbitrator made a mistake, but court, there's nothing you could do about it. It was his mistake to make. They signed an arbitration agreement, tough.
That is absolutely, and that is one of the many reasons that failed. The appeal fails.
I'm saying, do you concede the arbitrator, in fact, did not follow the process to take judicial notice of this fact?
Yes.
Okay.
But let me jump to one of the points the employer makes. He argued or mentioned twice or made the following assertion twice in his argument. That the arbitrator said, hey, tolerance has grown in recent years in Florida. And then he jumped to the conclusion that the penalty was excessive or harsh. If you read the arbitration decision, you will see that the arbitrator, that's a mistake. It's misreading the arbitrator's decision, because that happened close to the end of the decision. But in the middle of the decision and at the beginning of the decision, he said the same thing. This case goes the union's way. And in
Does it
fact,
make a difference that he wasn't under the influence at the time of the accident? We certainly don't want police and we don't want firefighters under the influence of drugs on duty.
I think it could have made a difference, but it didn't make a difference here because he wasn't. So that's a specific finding of fact. And in fact, there was a conclusion by the arbitrator that there's never been a situation where he was ever under the influence, any more than somebody that might drink alcohol on the weekend and then go to work the next shift. He was not under the influence on this day. That is a specific conclusion the arbitrator reached. And had it been different, that might have made a difference, but I'm only speculating about what an arbitrator might do. But going back to the point I was making on page 15, the second sentence of the report, the arbitrator says, quote, I conclude that while the grievant should be disciplined, and he was disciplined, and that's important to keep in mind, the penalty of discharge under these circumstances is simply too harsh. On page 16, quote, I find that the degree of discipline administered by the employer was not reasonably related to the seriousness of the crime. Then on page 18, the language that the employer adverted to in opening in the initial argument, that is where there is mention, largely in passing. It was totally unnecessary, and it may have been improvident. There's a reference to there being a violation and it being the penalty being excessive. So I think the structure of the argument suggesting that in the brief, suggesting that the arbitrator's decision turned on this improvident fact finding is simply absolutely unsupported by the arbitrator's decision.
Is there any procedure under the arbitration rules to seek rehearing?
Yes. And clarification and modification and
Was rehearing sought from the arbitrator?
no. Now, the court is familiar with the well-developed jurisprudence regarding deference to arbitration awards. And that was touched on in the lower court's decision. And beyond that, it's mentioned in the brief. And it's extensive. The court, like I said, is familiar with it. And the employer hasn't come close other than making the argument they made below, which was unsuccessful. And that argument was an effort to turn a garden variety labor arbitration case into something special, because this was simply your typical arbitration case. And that is somebody's discipline. The union files a grievance. The case goes to arbitration. The arbitrator has an issue presented to him. in this case, the issue was whether the employee was terminated for just cause. Just cause is defined in the contract as if there's two parts to it. First, was a rule violated? Second, there are three ways to overcome just cause. The third way, and it's interesting that the parties broke it out the way they did, is finding that a showing that the discipline was not reasonably related to the misconduct, the proven offense. Now here, there was no dispute about the proven offense. The guy tested positive for marijuana. In fact, after he had the accident, he went to management and said, hey, I'm going to test positive. A couple days ago,
Well,
I
that's
smoked.
because he knew he was going to be tested and knew what the test results were.
Exactly. And he tested positive. There was no finding that he was under the influence due to the level of the THC or whatever it might have been. And the employer read their policy as requiring discipline, or excuse me, termination, even though the policy provided for three options. One, you could go to EAP. Two, you could have a level of discipline short of termination, or you can be terminated. And the arbitrator, looking at all these facts, said, hey, this guy had a, quote, splendid record, firefighter of the year, those things that we're familiar with from the record, and said, I'm going to provide for a level of discipline and random drug testing, but I'm going to set aside the termination, which was all within his authority. And the employer, for whatever reason, can't live with a decision that Florida law says needs to be final and binding. And in that sense, because this is the collective bargaining agreement, 447-401, Florida statute says labor agreement arbitrations are final and binding. The employer challenged it. And in challenging it, the employer had to come up with a theory below, because the standard of review obviously didn't work. So the employer came up with a red herring, a bright, shiny object by which to attempt to distract the trial court judge. And that was, hey, he used the phrase arbitral notice. Let's construct an argument around that. And that's why we're here today. And we ask the court to recognize this argument, this arbitral misconduct or arbitral notice argument, and attempt to convert that into some sort of misconduct. We ask you to reject that, affirm the trial court's decision, and get this man back to work. Thank you for your time.
Two minutes and 31 seconds.
I've got a lot to say in a short period of time.
Why didn't your client move for rehearing with the arbitrator?
Because it wasn't authorized. And that's what one of the things I was going to respond to you is that there's nothing in the record or in the law that shows that you can do a rehearing. All we have is an arbitration award. And at the end of the arbitration award, the arbitrator says, I retain jurisdiction for the remedy, which is what happens if we have a dispute with back pay, if you don't get put in the right position. There's no rehearing. There's nothing under the Florida Arbitration Code either. To your question, I'd like to say, Judge Cohen, that about the under the influence. As a matter of law, he was under the influence by the Drug-Free Workplace Act. He's under the influence if he tests positive for marijuana. Whether that meant something or not to this arbitrator and whether it means something to you, I leave that for you all to consider, but it meant something to the city. And the evidence was that every single employee that had ever been under the influence was in fact terminated by the city. That's all the evidence that it was. Now, it gets down to exceeding his authority, because I understand Judge Mize's concern about misconduct. And when we look at exceeding his authority, he clearly went beyond what he was granted by the contract with the parties under the CBA. And I want to close with reading to you all what the Florida Supreme Court said. I understand Quesada, second DCA, you're not bound by that. The Savades case, that's the third DCA, you're not bound by that. But both of those stand for the principle that if an arbitrator does exceed his powers,
Counsel,
it can be reversed.
Doesn't any trial arbiter, trial judge arbiter, doesn't any time they make a legal error, they exceed their authority? So
Sure.
when a trial judge makes legal error, they exceed their authority. It's what it means to make a legal
Sure,
error,
but
right?
but the trial judge doesn't have a contract with the parties, an arbitrator does. And so he's exceeded, and that's what happened in those two
But
cases.
you're saying he exceeded his authority and you in your briefs, you analogize to going outside the record. It's within his authority to find this issue, right? Like you basically said, like when I was reading your brief, he had authority to decide whether the punishment was outside. He didn't have authority to, decide whether or not society views marijuana in a certain way. And that was a factual issue he found relevant to, the issue he had to decide, which is, did the punishment fit the crime? And to me, it seems to all boil down to, you're saying he committed a legal error, which the other side conceded. He was wrong. He shouldn't have done it. But legal error does not equal misconduct.
It does if it violates the contract. If I could just read with you just a minute what the Florida Supreme Court says, because it's the exceeding the authority. And the Florida Supreme Court in Schnurmacher Holding Inc. versus Noriega at 542 Southern 2nd 1327 at 1329. This is a 1989 decision of the Florida Supreme Court. Says that an arbitrator exceeds authority under Chapter 682.13 when he, quotations, goes beyond the authority granted the parties or the operative documents and decides an issue not pertinent to the resolution of the issue submitted to arbitration, in quotations. That's exactly what happened here. Thank you for your courtesy and the great tough questions.
Thank you, counsel. Okay. Now, if council is able to stay for a few minutes, we want to do a question and answer session with the students who are here watching this argument. And then also the judges will introduce ourselves as well, since we waited to do that after the last one. So should we start with that? Okay. Do you want to go?
I'm Jay Cohen. Some of you were here earlier, so I apologize for repeating myself, but I've been a judge for 33 years, initially on the trial court for many years, and then I have been on the appellate court for the last 14 years.
Okay. And same apology for those of you who have been here before, but I'm Carrie Ann Wozniak. I was originally appointed to the 5th District Court of Appeal, which is headquartered in Daytona, which is where Judge Cohen came from as well, about 2 years ago. And then as of January 1st, the 6th District Court of Appeal came into existence. And so people or judges who reside in the 6th District got moved over. So Judge Cohen and I both got moved over as of January 1st.
My name is Joshua Mize. I practiced commercial litigation for 11 years. The governor appointed me to the circuit bench in the 9th Circuit in February of 2021. I served there through the end of 2022. As of January 1st, I was appointed to the 6th District Court of Appeal.
Counsel, do you want to introduce yourselves? And please speak into the microphone because there's students listening online.
My name is Greg Hearing. I'm with a large law firm in the state, Gray Robinson, and I'm a labor and employment lawyer. I am not an appellate lawyer, as you can tell from my handling of the tough questions by the panel. But I am a trial lawyer. I'm board certified civil trial and in labor and employment law and in education law. But I have to say, if I may, Your Honors, this is the funnest part of my practice, because in trial practice, I go against very smart advocates, but I don't get challenged like I do and did today by three very incredibly smart legal minds. And so it's truly the epitome of what I think the practice is. And I would like to do it more often, but it would usually mean that I lost probably below if I did. But I do find that it is more challenging than even trial practice, because instead of trying to convince 6 or 8 strangers that aren't trained in the law and that are told by someone in a robe what the law is and they have to follow it, I have to convince 3 highly trained, highly experienced people in robes when we come up on appeal. So it is something that if you do go to law school, I would commend you to look at doing this area of the law, because it is the most stimulating part of my practice.
My name's Rich Sawicka. I'm with a small firm compared to Greg's firm in Orlando. We represent labor unions. That's why we are labor lawyers, not so much labor and employment lawyers. I won't bore you with what the difference is. What we do is represent unions all over the state, and for example, all the employees at Disney, the professors that teach in this building, and many firefighters unions around the state. So, which is what this case involved, as you may have been able to pick up. And labor law is a very, very interesting area of the law. I'd say 60% of our practice involves private sector labor unions, which involves administrative law largely before the National Labor Relations Board. And so we get a good mix of the kinds of employees and the kinds of issues. But labor cases are frequently in the appellate forum, and normally the same lawyer does the case all the way through for whatever reason. It just tends to work that way, which is why you see like a different approach, I think, to arguments than you would see with just the pure appellate lawyers, people that only do that. In any event, I think we both hope you enjoyed the oral argument.
And now if anyone has any questions, either for the judges or for the council, please raise your hand. Go ahead. And that's for, you all can, don't ask us questions about the case, but you can ask council questions about the case. So I assume that was directed to council. Council, can you please repeat the question into the microphone so that the students can hear who are online?
And you can ask those questions, just not about the case.
Yeah.
Yeah, the distinction between mistake and a legal error or something like that, I think I heard. What? Oh, I guess I think speaking generally to that is that question goes to whether the underlying arbitrator's decision was subject to being challenged, characterizing the thing he did. And the thing he did was say the following: I recognize society's tolerance to marijuana usage is, well, a growing tolerance or something like that. Increasing tolerance. And he said those words in a case involving an employee who was terminated for smoking marijuana. And the question is, should he have done that when he was evaluating the propriety of terminating that guy for doing that?
And if I could add to that, I would say the reason that I argue misconduct here, it comes from a statutory ideology. It comes from a statute that says that an arbitrator shall not do the following, and one is engaged in misconduct. And that could be different than legal error. Legal error could be letting something into evidence or not, or proper and improper instruction to a jury. And so my argument before the court today was that this is unique to this Florida statute, and it was terrific questioning about how that applies though to an arbitrator. And so there's a difference between the two, at least as it relates to the statute. If it relates to a judge in a trial court making engaging in misconduct versus legal error, there's a difference there too, from my perspective.
Did you say this is a legal document or?
It was in, what happens in labor arbitration is the parties, and this is not like a trial, so it's a great follow-up question, so you all understand the difference. You, like the prior lawyers that were here, that would be in a lawsuit, and the first one was an employment lawsuit. I thought it was very interesting. You all had 2 employment cases on your docket today. It's amazing because it's hardly ever one. But what you do in a trial, in advance is you have what's called discovery. People sit for depositions, you get documents, you exchange them. Arbitration is entirely different. It's trial by ambush is what I like to say, is we show up. I don't know what Mr. Sawicka is going to say, and he doesn't know what I'm going to say or argue or who I'm going to call. You don't even have to disclose your witnesses, your documents, anything. And so what he did, and then he takes all that evidence in, the sworn testimony of witnesses and documents, and then takes argument by brief usually. Sometimes there's an oral argument at the end, but we did it by brief, and then issues an arbitration award. And that's the legal document that has binding legal authority on the either party, whether, you know, whoever wins or loses. And in this case, the city was ordered to reinstate this firefighter with a 30-day suspension by this arbitrator. And it has, because it has legal import and it's under that Florida statute, the Florida Arbitration Code, we did have a right to appeal it both to the circuit court and to this court. If the circuit court, if we could satisfy this panel, the circuit court made error. So does that answer your question? Thank you.
Go ahead.
I have a question for the bench, actually, and members of the bench can answer the question, but what are you looking for in an effective oral argument, not necessarily limited to the content of the argument, but actually taking for?
Who wants to go first? I can take that. So I used to be the person arguing before I got appointed, and I would say the way I prepared for an argument was I had to be so familiar with everything in all of the binders, the record, the cases, everything, that I could explain the case in a couple sentences to a 5-year-old. Or at least someone untrained in the law completely. And if I wasn't able to do that, then I wasn't ready for oral argument. And I think all of the council today have been superb with, you know, knowing the record and all of that, being prepared today. So that's, I guess, the biggest thing for me is being so prepared, being able to answer the questions so quickly. Where in the record was that? Oh, that was page, you know, whatever. To be able to do that and make it look easy means that there was a lot of preparation involved.
And notice how thick the binders are that they do that with, right? So to know what page to go to, that's like, all right, out of the 2,000 pages, let me go to 1131. I think in any case, whether it's an appellate or trial proceeding, you know, you typically have a lot of moving parts, and the best lawyers know how to get to the essence, right? So you might have 1,000 different, you know, moving parts, facts, legal issues, and there might be 2 or 3 that the case hinges on. And figuring out what are the crucial parts of a case, and how do I explain those, you know, to a judge, jury in a persuasive way, is very difficult, and the best lawyers are good at it.
I would say that the best oral arguments are conversations with the court. Because that's what this is about. It's about having a conversation about certain issues that are in an appeal, or in this case, from an arbitration award. And the lawyers that are comfortable with that are the lawyers, I think, that present the best oral arguments.
Maybe we have time for one more question if there is another one. Okay, go ahead.
When you ask questions to the attorneys, are you asking the questions knowing the answer, or are you asking the questions to kind of brush on?
That's an excellent, well, the question was, when we ask questions, are we asking the questions knowing the answer, or are we actually seeking real legitimate responses? That's how I would rephrase that. there are a lot of reasons that you ask certain questions. Sometimes you're asking questions that really what you're trying to do is persuade another member of the panel on an issue that you think you might need some help in persuading them on. But very often, you've spent a lot of time, we spent a lot of time preparing for, every case that we handle, including oral arguments. And so we've gone through the briefs, we've gone through the record, and we have certain questions about the case that we think need clarification or that we think flow against their position. And obviously, you could probably, it's not supposed to be a game. I think lawyers ought to be able to go away from an oral argument with a pretty good feeling for how the case is going to be decided. It doesn't always work that way, but very often it works that way. And so that's what we're doing. And you could see from my questioning of counsel that I had some questions about the way that is this, whether there was error that needs to be corrected, because that's what we do. We're a court of correction of error. And so those are the questions that I'm asking, and I'm asking them because I legitimately am probing the weaknesses of his case. And if I have to write an opinion in a case, I want to be comfortable in applying the rule of law that I'm going to be writing on in other cases. And so sometimes I'll just probe to see, well, how would this rule of law apply in this factual situation under these circumstances or these circumstances? Because I don't want to write something that's going to cause a problem for other litigants and the citizens of the state of Florida in other cases. So that's my response.
I agree with everything that Judge Cohen said, and I'll add that sometimes attorneys don't recognize an easy question when they get it and get flustered and think it's way more complicated than it is. Sometimes the questions are easy.
It's easier for us to know that they're easy questions.
True, very true.
Yeah.
Go ahead.
I don't even know.
Great. Well, thank you all so much for being here today. I am going to be swearing in two attorneys who just passed the bar. I think that they're here. So if anyone wants to stick around to see new attorneys get sworn in and see what the oath is like, you're more than welcome. Otherwise, court is out of session.
Oh, not a second.
It's me. I don't know if Charlie is doing the announcement. Need them all rise.